the defendant in the eye and explain to the parties the factors she considered in deciding on the sentence. She does this coolly, logically, and without rancor. When she concludes by imposing the sentence, the parties know she has followed the law, and the defendants seem to appreciate that she took the time to speak with them. A few actually seem to be smiling and nodding in agreement as they head to the House of Correction. One of Judge Rayburn's most endearing assets is her great sense of humor, which I appreciate and share. The truth is that while working in the courts, a sense of humor becomes a necessity, a sort of survival mechanism. Now, I'd like to step back from speaking about the Honorable Judge Rayburn and instead speak to you about Katie. She is the woman who leaves her robe at the courthouse each day and heads home to assume her primary role as a single mother raising a son on the autism spectrum. She is a woman who, like an accomplished juggler, balances a judicial career with a career as a mother and is brilliant at both. Even more notable is that she could complain, but she doesn't. Let me tell you about a woman who is a member of the same Peloton cycling group as myself, is awake each morning at 5 a.m. and driven by a fierce, relentless sense of competition, tries to beat me on the bike. She never beats me, but she's the first to congratulate me on a great ride. She's a woman who leaves a stressful day presiding over a myriad of cases to go home, cook dinner, and spend hours helping her son Nathan complete a 3,000-piece Lego set. She's a woman who, after a long week in the courtroom, takes Nathan to New York to see the painting George Washington Cross in the Delaware at the Met because Nathan really loves history. More importantly, she is the same woman who, following weekends like this, appears in court each Monday morning, energetic and determined to bring the same passion to her judicial duties as she does to her maternal duties. I find her extraordinary. Finally, I know I only have a small voice in these proceedings. I know that neither I nor my colleagues have a vote. I can assure you that if we did, we, the people who know Judge Rayburn best, we would be voting in support of her appointment to the Superior Court. I can only ask that you counselors do what we cannot. Should you do so, I'm certain in the years ahead, each of you will look back upon your vote with great pride. Thank you.
Thank you very much. Thank you. Next, we'll hear from Judge Daniel. Counselor?
I'd like to ask a question.
Okay, you came a few minutes late, but yeah, I didn't know. I didn't even see you there. I'm sorry. Yes, Counselor Devaney.
Tell me, working relationship is with nominee.
I'm an assistant clerk. Oh, I'm sorry.
I know
Okay.
that, yeah.
So we've worked together in the courtroom, and then we have worked. I'll assist her when she has motions, if she needs something to be sent out, dealing with the attorneys. I act as a assistant clerk, kind of acts as the between the parties. And then we do have as they mentioned, I think you must, we do work out together on our Peloton bikes.
That's great. You're shaming. But so you, so how would you describe her, give me an adjective that you think she's bringing to, we already know what she's done.
Compassion, patience, and besides her knowledge, you know about her knowledge. You'll know that she knows the law. Separate her from other judges.
No, I do know that, and I was proud to vote for her the last time. And this is what we like to see, someone elevated to a court that has shown that they,
Yes.
But you said the magic word, compassion. That's what I was.
She has, and that's what.
The first thing you said.
Yeah, no, and she, as I mentioned, unfortunately you missed, but speak with me, 25 years, that people want to be heard, even in hearings that I conduct. If you give someone the time, even if you find against someone, if you've given them the time to speak and they feel like they've been heard, they're satisfied. And that's what Judge Rayburn.
I just wanted to tell you that every clock in the state house is different. Ours is 5 minutes slower than this one. And so I was 2 minutes late, but I'm so glad that you spoke. I want someone that has worked with her through the years, And I said before, sometimes we have someone as a witness and I say, well, tell me your experience with this. Well, I saw him once in court.
Oh, no.
That's not it. That's not
go
good.
day in and day out.
Right. So that's my testimony and so forth. Thank you.
Thank you very much. Appreciate the time.
Now we'll hear from Judge Daniel O'Malley.
Thank you.
He's going to sit where you are.
Oh, no.
Sit, excuse me, Counselor. You can sit over here. Thank you.
Would you like to sit here, Counsel, or stand?
You can stand or sit there, your choice. Excuse me, Counselor.
Thank you.
Excuse me,
Good morning first.
excuse me, Counselor, I'm chairing the hearing, you're chairing the hearing this afternoon. You have two options. You can stand over there. Excuse me. You can stand over there or sit there.
Thank you, Counsel. I'll sit down.
Thank you.
Good morning, everyone. It's my honor and pleasure to appear before this council and to testify on behalf of Judge Rayburn. I met Judge Rayburn in the 2000s when she was Plymouth County ADA Katie Cook. She was quiet but diligent. I make observations of her when she was working. We had cases against each other. We never went to trial, but I just watched how hard she worked and how into the job she was. So when it came time that I needed to hire another associate, one left, and I offered a job to ADA Katie Cook. And she came to work with me, and the first thing I said, I'll only ask you to work half days, 12 hours. So Katie came in, hit the ground running, work. She worked every single day. When I mean every single day, Saturdays, parts of Sundays, would be on the phone talking about cases. She did anything and everything I asked her to do. My practice was quite busy at the time with regard to court appearances. I was in multiple courts every single day and going from trial to trial. And even though I liked to write and I thought I was okay at it, I couldn't do it anymore. So I turned it over to Katie. I said, Katie, you're going to have to write. And at first, her writing was adequate. And it was adequate. And when I told her that it was adequate, I think the expression I got was like I had just kicked her dog. And she didn't even have a dog. But what Katie did is that Katie just became a better writer and a better writer and a better writer, to the point that her writing is fantastic. It got to the point where I never proofed it. I just took it and went off with whatever the memorandum she might have written, the cases that she would give me in support of our position, but also the cases that went the other way, as to which I would have to distinguish. Did a tremendous job as a writer. And she didn't come in as a great writer, but she left as a great writer, and she's still a great writer. The reason I bring that up is because of challenge. I always said about Katie that challenge should be a middle name. Whenever she's challenged, she meets it and then exceeds expectations. Always. It's incredible how she does it. She did everything and anything in my office that I asked her to do. Conferences, she did trials, she did pretty much all the civil. She did when I have an occasional family law case, which I just wasn't very good at. Katie would take it. She just was my right arm. So 2007. In 2007, I was sick, real sick. I was in the hospital 7 times over 13 months with 4 surgeries. I was a solo practitioner, but it was Katie Cook and me. That was it. When I got sick, it was Katie Cook for roughly 13 months. And the only word I can use to describe her performance is incredible. She just put the practice on her back and kept it going, where otherwise it would have gone right down the drain. She did everything. When I kidded about her working 12 hours a day, that was a short day when I was sick. She works every single day and kept all the balls in the air. There was one particular time I'm still not happy about, but I'm proud of how she handled it. What I'm not happy about is this. We had a very high-profile Superior Court case that I was going to try. And Katie conferenced it because I wasn't able to. And the judge was pushing her to settle it or try it and say, well, Dan O'Malley's not available right now. Well, then you're going to have to try it. And the judge was trying to big time her into a plea or force me to come in and try it. I couldn't, and she did. the judge tried to make Katie cave, and she wouldn't. Katie stood tall. She tried the case. Again, a serious case, a high-profile case, got a split verdict, just did a tremendous job in the case. Why? Because that was the challenge that was before her. She met the challenge again. Incredible work ethic, energy, and as Kerry DeSanto said too, compassion. And I'll give it another one too. So important when you're a judge. It might sound trivial, but it's not. Common sense. She's lived. She's not full of herself. She's just a regular, down-to-earth person. And fast forward a little bit to when I testified before this body, I think it was 2017, when Katie Cook Rayburn became Judge Rayburn. I can't tell you how many calls I got, because I'll tell my kids, say, Dad, how come you know everybody? And I said, because I'm old. And I would get calls from other court people where Katie would, Judge Rayburn would go in as a judge, from lawyers and from court people, and say, wow, that woman, she is terrific. She's fantastic. Well, I think you all know the past several years, she's just done a wonderful job as a district court judge, and she'll be a better Superior Court judge. And you might wonder, well, how can you say that? I can say that I get a telephone call from one of the Judicial Nominating Committee commissioners when he was doing his due diligence, and we went over different things. And I told him, I said, she's going to be better in the Superior Court. And he goes, you're not the first one to say that. Because of her love of the law, her knowledge of the law, her ability to write, and her work ethic again. Last thing I'll say with regard to work ethic is this. She won't tell you this, but I'll tell you this. During the pandemic, she worked pretty much every single day in the session, and she was in New Bedford one day. Chief Dawley has a saying about the New Bedford District Court. If a judge can work in the New Bedford District Court, a judge could be a judge anywhere. And I worked there for quite a while too. It's back to that wording. It's a challenging place. Anyways, Katie was in the first session, which is just in the house, no clerk. Instead of shutting down the session, she did the session. She did the clerking. She marked the papers. She called the cases. And I think it was like 80 or 90 cases on that day, which isn't unusual for New Bedford or Fall River in the main session. But that's just how she's wired. Something's in front of her, a job, a task, a challenge, you consider it done. I am so proud of her, not only the lawyer she is, the judge she is, but the person she is. She's a woman of incredible integrity, class, dignity, and humility. Notwithstanding the success that she's had over the years, she's as humble and regular as anybody you would meet on the street. So it's with much enthusiasm that I testify here on her behalf in her quest to be a Superior Court judge, and welcome any questions.
Just, I just got a quick question. It's something that always bugs me about judges. You alluded to the fact that you're in the hospital, you were sick for several months. Your associate went to court, and the judge was, I'll use the word, pressuring her to either plead the case out, I assume it was a criminal case, or to try the case. Why does that happen? Hold on one second. It happens not a lot, but even a few times is too much. You know, I asked a question of a nominee within the last 2 years about, there's a female nominee, and I said, well, what if your husband surprised you on the case of, when it was their 25th wedding anniversary, and in my hypo, and he surprised you to take you to Bermuda. Would you grant a continuance? And the woman said to me, no, the husband should have known about his wife's schedule. I go, are you serious? Are you kidding me? So my question is, why do these judges care if it's continued? I assume it wasn't the 10th time continued. Stuff like that really irks me, and I just think it's not right.
Me too, and it's happened to me over the years as well. I give you one. I had to go to something for my son at school, and he had some special challenges, and he had overcome them and something at school. And a judge forced me, no, wouldn't give me a continuance. I missed it. My wife went in and videotaped it, but there's no excuse for it. There's no reason for it. It's bullying, and that's a strong word. I don't care. It's bullying. And, it's getting you, and with all those who practice here, no, it's better now. It's better than it used to be.
Thank you.
And it is infrequent.
Yes, definitely it's infrequent.
It is, but it's one time.
It's too much, yeah. Thank you. Any other questions of the judge? Councilor Devaney.
Counsel, nice to see you.
Nice to see you. How many years?
How many years now? Second time, 16, so 6 years. Thank you.
Well, but I have to tell you, that there's no one more humble than the judge, but I know, even speaking here today, you kind of glossed over all the things that you've done, and I want to thank you for your service. And I followed it, and I'm so proud of that vote.
Well, thank you.
And to have you come and speak for this nominee. Now, what I look for someone going to Superior Court, and you said it, writing skills. She has it.
She does.
Saw it in the JC. I loved it, her writing. And we had a judge that we weren't told about, but he went from the district court to the Superior. He said, too much writing, I want to go back to the district court. I can't even believe that, but she wants it because that's what she's best at, So, I love that you talked about her qualifications and also her personal traits. And I can't separate the public from the private when I vote for someone. And can you tell me something that you have witnessed in her personal life that carries on to the
Sure. I'll tell you about her devotion to her son, And one of the reasons, maybe the main reason, although I'll let Judge Rayburn speak to that, is that we worked for 3 years or so, and then she went to the Bristol County DA's office, is because the pace of our small practice was just, as you heard, crazy, 7 days a week, she left it, took a pay cut, went to the DA's office because her son needed her more than I needed her. I'm not so sure about that. Right? But no, there's one example right there. And she said, no, I want to go left to a great girl. And Nathan needs me.
Well, I do want to say briefly, you look great. Sorry you went through all of that. That must have been a devastating time for you.
Well, yeah, but it was long ago, and God is good. And I feel great. Well, thank you. Thank you, Counsel.
Thank you very much, Judge. It's always a pleasure. Thank you. At this point, is there anyone in opposition to the nomination of Katie Cook? Reborn? He was not. That will conclude that part of the hearing. And you can sit anywhere you want, but most of the time the folks sit over here or over there.
Yep.
Thank you. At this point, Judge, before we hear from you, if you have any family or friends, relatives that you'd like to introduce, you can do it at this point.
This is my father, Richard Cook, my brother, Andrew Cook, and two of my former colleagues, friends, and we used to work in the DA's office. This is Garrett Frago. We were longtime DAs together, and now he's an assistant clerk magistrate and does the civil session in Taunton in Superior Court. And this is Liz Souza, who is a defense attorney in Bristol and Plymouth counties.
I think the chief is here.
The chief is here as well. Thank you so much for coming.
Good to see you again. Okay, at this point, we'll hear from you. Give us a presentation as why you think you'd be a good addition to the Superior Court.
Thank you so much. And before I get there, I want to take this opportunity to thank all of you for giving me the last 4.5 years as a district court judge. They have been nothing short of wonderful. To get the opportunity to work in Region 1 with some fantastic judges, and to get the opportunity to work in New Bedford and Fall River, those communities have mean a great deal to me. I went to school at UMass Dartmouth, so I spent my younger years down there, and I was an assistant district attorney there for 10 years. So those communities mean a great deal to me, and to get the opportunity to go back and serve as a judge and help the community, I can't say enough of how much I've appreciated. So I want to start by saying thank you so much for the last 4.5 years of my life, because they have been wonderful. And today I'm here asking that I be considered for a position of an Associate Justice of the Superior Court. I want to start by thanking Governor Baker and Lieutenant Polito, the members of the JNC, the Chief Legal Counsel Robert Ross, Executive Director Lauren Green, Emily Gauthier, Valerie McCarthy, as well as the Joint Bar, my friends and family for their support, and of course, all of you for your time over the last couple of weeks and all of your time here today. Thank you so much. For as long as I can remember, since I was a little kid, I wanted to be a lawyer and a part of the legal community. Now, I don't have any lawyers in my family, so I can't ask you exactly why, but I knew as soon as I knew what a lawyer did, helping people, being in the courtroom, that's what I wanted to do. From when I was probably 10 or so, it's all I've wanted to do, and I knew that the path that I was going to take. But I also knew it was going to take a lot of hard work to get there. And that's what I learned from my parents growing up, was the importance of hard work. My father, who's here with me today, he grew up in Somerville, drafted at 18, returned from Vietnam, worked nights, went to school during the day, and helped my mom raise 2 kids. My mom grew up in a very small town in Nova Scotia, Canada. Unfortunately, her father passed when she was just 3 weeks old, leaving my grandmother with 4 daughters under the age of 5 to raise all by herself. My grandmother actually went back to school, put herself through school, and became the first female principal of Nova Scotia. My mom went to school, became a nurse, and moved here, married my dad, and together they raised the 2 of us. Throughout my entire upbringing, they demonstrated the importance of hard work to me. And from the moment I begged my mom to take me to the Norwell Town Hall to get working papers so I could work at McDonald's, to now, I have always strived to work very hard and to be the person that my parents have raised me to be. But I also know that hard work sometimes is not enough. And I know that I've been very lucky over the years. I'm lucky to have family and friends that support me and have always supported my desire to be a lawyer. And I'm lucky for the opportunities I've had along the way. I'm lucky that I got to work for Attorney O'Malley, and I'm lucky I got to work for District Attorney Thomas Quinn. They have given me amazing opportunities. And I was lucky to get the job as a district court judge. So with that, knowing how lucky I've been, I hold myself, and I think that Judge O'Malley touched on that, I hold myself to a very high standard. I push myself to be the best. And I have certain expectations of myself. And I know you, when you gave me the position that I have now, you had expectations of me. And I have tried over the last 4.5 years to learn from my wonderful colleagues, to learn from the court staff, whether from the court officers to the clerks, to learn from the litigants in front of me, and to listen more than I talk. And I hope that I have lived up to the expectations that you all had of me 4.5 years ago. And I want you to know, should you consider me for this position, that while I will strive to continue to improve each day, to continue to grow, to work on my writing skills, to work on my listening skills, and to be the best, because I want you to know that I don't want to just be a good Superior Court judge, I want to be great, because that's what I want, I expect of myself, that's what your expectations are of me, and that's what the people of the Commonwealth of Massachusetts deserve. They deserve to have great judges, and my son deserves to have a mom he can be proud of, and I hope that I can do that. So thank you very much for your time here today.
Thank you very much. At this point, we'll hear from Councillor Eileen Duff.
Thank you, Mr. Chair. Nice to see you. It's interesting. I got my working papers at 14. My paper. Forget about that, actually. You have a great resume and you're clearly qualified, but do you have any experience in public defense?
When I worked for Attorney O'Malley, I did defense work for 3 years.
Right. And I remember you and I spoke a lesson about this. How about, what do you think the biggest challenge you will be facing in Superior Court?
Well, I think there'll be some personal challenges as well as work challenges. I think that civil is going to be a challenge. Now, when I first got out of school, before I became a DA, I did do just civil for about 2 years, but that was a long time ago. And then I did all of Attorney O'Malley's civil, and I have done as much civil as I can in district court, but to be honest, over the last couple of years during COVID, civil certainly took a backseat to criminal for obvious reasons. So I didn't get as much as I would like. So I do think that civil is going to be a challenge I look forward to. Personally speaking, I think that there is a difference between district and superior, the amount of judges. I think it might be a little bit more isolating. So that's what I see as sort of a personal challenge, but professionally is going to be the civil. But I really, over the last couple of weeks, I've really tried to prepare myself as well as I can. I've read through the rules, reviewed the rules of civil procedure. A friend of mine, as well as Garrett, is also a clerk. I scheduled a meeting with him. We talked for about an hour about 9A, medical tribunals, rereading 209A and understanding the difference. So I really have tried. And I do think that with civil, with any case, but I think the great thing about Superior Court, unlike district, is in district court, you may not even know what session you're going into until 3 minutes before you walk in. But I think in Superior, you know what your docket's going to be. And I think it's all about preparation, taking the pleadings ahead of time, reading them, preparing. I think you and I spoke a little bit about some of my favorite judges. Judge Kane, for example, he would come ready. He'd have a list of questions. He's ready to go before you've even said anything. So that's what I would strive to be. It's really about being prepared and learning as much as I can. So I think civil will be my biggest challenge, but something I look forward to.
Great. Yeah, I think the courts have done a tremendous job during COVID in adapting and adjusting, and making the most of the technology. And in many cases, they're going to continue to retain some of that technology. And I've, spoken to Judge Borges on the state Supreme Court. He's the head of the Access to Justice Committee, and how we, the Commonwealth, will be employing this technology going forward in basically access to justice, getting people. There's been a little bit of a silver lining in some of this for folks, and I applaud our court system for adapting, and really in a global pandemic. Have you done many jury trials?
As a judge, yes, more than 25, somewhere between 25 and 30, or obviously it would have been more, but COVID, but I would say at least 25.
Yeah, that's significant. I ask because jury instructions are very important.
Yes.
I've sat on I think we may have discussed this, I sat on the jury of a Superior Court civil case, and it was an absolutely fascinating experience. And being in the jury box, Counselor Jubenville has taught me a lot from listening to him as a trial attorney. Sometimes we couldn't hear very well. I knew to raise my hand and ask to have people repeat. It was just, but making sure the jury really understands what their job is. We had a great judge, and we had great, clerks and everything in the court officers. I mean, they were just tremendous. But as I've spoken many times, I have a constituent whose dad was brutally murdered in a terrible case. And it wasn't civil, of course, it was a criminal case. He was a police officer. And the murderer was actually let go on a technicality on jury instructions. And so it's really, it's affected this man and his family and his community for the rest of their lives. And it's, no one tries to do the wrong thing. No judge wants to make a mistake, but we all, as you said, we don't want to just be good, we want to be the best. So also, do you feel that you have a strong support system around you?
Yes, I'm very lucky. My son was unfortunately born 14 weeks premature, so he was in the hospital for a very long time. And rather, because of his immune system and he was on oxygen, he wasn't able to go to daycare. And luckily, I had my mom unfortunately has health issues and can't be here today, but I had two amazing parents who literally stepped up, and instead of going to daycare, Nathan went to my parents' house every day so I could go back to work, and they've kind of become sort of second parents. So I have my son's father lives 2 towns away. We're excellent co-parents together, and my father picks my son up 3 days a week from school, and I have my son, and Carrie spoke to this, is on the autism spectrum, but he's at a wonderful school. We have a great IEP. I have great programs. He has something every day after school. So I have the most amazing sports
How
system.
about not just that, when I ask a potential judge or a judge, as you already are, about their support system, I'm concerned, because of the way society is today. Our judges are gravely attacked a lot. I mean, it's almost a daily occurrence in the Herald, right? You know, you're all living off the land and you don't do anything in your hats and everything else. And there may be a time you're a young woman, there may be a time you make a decision that is unpopular. There may be a time when you do something when someone goes back out and commits another crime that is horrific, like the one we just talked about. Those are the times you need a strong support system around you of peers, of friends, of family, you know, what I sometimes call the spiritual support system, and not meaning in a religious way, but, you know, people that can really hold you up, you know, your ex-husband, your partner, your whoever, because it's tough.
It is, and I have, from a different perspective, experienced some of it when I was a prosecutor. I did have a case where I did receive a fairly serious death threat, which was mailed to me, and the person was ultimately federally prosecuted, and I had to be fingerprinted and meet with the police, and I had to have the local police outside the house and that sort of thing. And I have had other, not as serious threats. I've had other issues over the years of harassment and things like that as my job. So I do, again, it's different than being attacked in the press, but I have had situations where I have had to rely on my support system, and they've been wonderful and helped getting me through those situations.
Sorry that happened to you. It's unfortunate. It's, you know, unfortunately in the world we're living in today. But it concerns me greatly that, you know, we had this happen a few years ago to a Superior Court judge in my district. He's no, you know, he's since retired, but the way that public officials spoke about him, calling for his head on a stick and such, you know, he should be impeached because they didn't like his ruling. Now, I don't know that I liked his ruling either. But here's the thing, he was the judge and he saw things and he was privy to evidence that we were not. And we must never forget that.
Absolutely.
Because that is when we start to disintegrate. That's when the separation of powers really gets called into question. And, you know, I don't know why he did what he did. Got me. But the fact of the matter is there's a way to behave. And I think we're on a very slippery slope, especially when public officials you know, join in the chorus of rah-rah. It's nice to pander, you know, to the camera, to the news and everything, but it's really not the best thing for the Constitution and for the public. I don't have any further questions. Thank you for the.
Thank you very much.
Thank you much, Chairman.
Thank you. Counselor Terry Kennedy.
You may be surprised to hear that lawyers talk about judges.
Yes, they do.
And, you know, Counselor Jubenville and I probably spend the most time in court of anybody in this room, in counselors. And one thing we hear about a lot is when we voted on someone and they're not doing a good job, not treating the lawyers the way they should be treated, or the litigants the way they should be treated. We very rarely hear good things about people that we put on the bench, but we always hear about the bad ones. Surprisingly, you know, since you've gone on, I don't know that I've appeared in front of you. I don't have a memory.
So,
But surprisingly, I have heard about you. All good things.
I wasn't sure where this was going, so
Setup.
thank you.
Wait a minute, he's next, so.
Yeah, that's right. It was a setup. But no, no, and that's unusual, very frankly, especially where you're not in an area that I practice. And I've heard a lot of good things, not just from lawyers that have been before you, but from your colleagues.
Thank you.
You're very, very well respected by your colleagues. We had a judge in here a few weeks ago that we got calls from some of his colleagues where he wasn't quite respected. by his colleagues, but, you know, it's been nothing but good things.
Thank you so much.
And I think that speaks volumes about how you're gonna be on the Superior Court. No question, you're a hard worker. And I think that's what judges respect the most, is people who come into a court, roll their sleeves up and help out. Which isn't the case with everybody, as you're aware, I'm sure, without, you don't have to respond to that, because I don't want to get you in trouble with your colleagues, but,
Exactly, thank you.
you're gonna get a lot of pressure in Superior Court. You're gonna get a lot of pressure from my friend Judge Locke, who I was in the DA's office with a century ago. And you're gonna get a lot of pressure from the Chief Judge, because we have this enormous backlog, especially in Superior Court. I think Suffolk is saying that they're not gonna be able to do many Superior Court trials other than murders for the next 2 years, because there's no backlog. And while you're getting that pressure to move cases and get things going along to try to clean up that backlog, something we all want to happen, but how are you gonna handle the situation that Councilor Iannella described, when there's some lawyer in the case is 3 years old because of the pandemic? And I've been in court where judges are looking at me saying, hey, this case is over 2 years old, we gotta move this. Very recently, it was 3 years old because of the pandemic. It's not my fault. It probably would have been anyway, but that's a different issue. But the point is that, you know, you're gonna get a lot of pressure to move cases. You're gonna see serious cases that you prosecuted, like rape cases and murders and everything else. Obviously, murders you have to be very careful of because of the stakes. But how are you gonna handle the pressure of them telling you we have to move these cases, and the litigants saying for one reason or other, we can't do this yet? Whether it's a vacation, whether it's someone being sick, whether it's they're having trouble getting an expert witness in there, whatever it is, whether they just need more time to prepare.
I think it's a balance. I do think that one thing judges have to do is trust the lawyers that are in front of them. I do, and obviously, no one likes it when cases get old, but one of the things that I enjoyed when I was in Superior Court as a district attorney is that most of the judges understood that each case has its own sort of natural progression. And the lawyers understand that now it's ready to be tried. I think that if you trust the lawyers that are in front of you and you trust their experience, then if they're telling you they're not ready or another reason, then you have to trust that you cannot push them to go to trial, that it's not ready. And with the backlog, if that one's not ready to go, there's going to be another case that is. So I think that as a judge, and having been a DA and a defense attorney, but working in Superior Court for a long time, you have to trust the lawyers that are in front of you.
Okay, but you're sitting there in the Superior Court when you say there's another case that's gonna go. You cleared the docket for a week for this case, that's a 5-day, 6-day trial, whatever it is, a drug trafficking case, rape case, whatever it is. You cleared your docket, everything else is pushed off, sometimes for months and months and months, and the lawyer shows up and says, I can't do it. It gives you whatever reason.
It's not ready, I can't, I'm essentially I'm working in an appeal. If I force a lawyer to go to trial who's telling me on the record not ready, then, and that's a problem, gonna run into, then I'm basically guaranteeing an appeal. So to force someone to go might be futile at that point. It's frustrating. I've cleared the docket for a week.
You know that all your future colleagues don't agree with that and would push them, even today. You respect what Judge O'Malley said, but there are some lawyers there's some judges that will still push you to go, whether you're not.
If it's a lawyer that's consistently saying, I'm not ready, and that's what I know, then that's different. But if it's a lawyer that I know
You know, generally, when you have people in Superior Court handling serious cases, they're not people that are there fooling around.
Exactly. And I need to trust that they're usually ready and there's a good reason. So I think it'd be frustrating, obviously, that I've cleared the docket for a week and probably would hopefully call in some pleas or a motion to suppress or something to fill the day. But to force someone to go to trial when they're not ready is just fraught with peril, I guess would be my.
I obviously encouraged you early on to apply for this because I think that you're somebody that the Superior Court needs. You know, we need somebody who's really smart, that's experienced like yourself, and we need women in Superior Court, which I said to you when we spoke on the phone. And I hope the Chief Justice appreciates that I've been trying to put some women onto the Superior Court. But not just women for the sake of women, but very smart people who will be able to do the job, and you certainly fit that bill.
Thank you so much.
You next week.
Thank you.
Excited about voting by you.
Thank you very much. Councilor Paul DiPaolo.
Thank you. Good morning.
Morning.
I've heard a lot of good about you, actually. I got more phone calls about you, actually, than I have in a while. Well, that's not true. There was one nominee who had some interesting phone calls about.
Okay.
But I do want to know a little bit about your perspective, because I certainly think your experience and the feedback, even as being positive. So I have a concern, that I'm not the only one, that we want to have a balance on the bench between prosecutorial and defense experience. You do have both. And interestingly, you started in a DA's office, you did some criminal defense, and you went back to a DA's office.
Yes.
So I'm wondering, and am I correct that you didn't do any defense work prior to your initial DA?
I actually did. I was actually a 303 certified lawyer, and I did a public defender's clinical, and I was in Somerville District.
I'm sorry, I did see that. So being on the defense side in between those two tenures, did that impact your perspective at all, or did that kind of add nuance to your perspective?
It completely changed my perspective about many things.
I would love to hear some.
Starting from the small things about continuances or when lawyers would show up. When I was a young DA, and I was 25, 26, 27, fresh out of school, and, probably didn't know much about anything, right? I don't know too much about the court system. And lawyers would show up late and I would get frustrated. And then when I worked for Attorney O'Malley, he's not kidding about the 12-hour days. Some days I would be in 4 courts, which meant I was always late to 3 of them, right? So I'd call, but and I tried to go to the court where I knew I was I'd most likely get in trouble if I didn't show up on time. So I tried to, manage it. Then when I went back to the DA's office, I'm like, well, why do I care when they show up? I'm here all day anyway, and they might be very busy and they're trying to make money. So that kind of thing. Other things that probably aren't relative right now because they've changed, but back a long time ago, a lot of cases had license loss attached to them. Many cases, drug cases that don't anymore. But I remember not thinking when I was a young DA about the collateral consequences of a license loss, because I guess I just wasn't thinking that. I was just trying to get my feet under me. And then when I worked for Dan and realized, okay, well, this is a guilty, guy can't work for 6 months. That's a big deal. So when I went back as an ADA, I really tried to factor those smaller collateral consequences became much more important when I got back.
Sure.
Also, I was a DA, thank you so much, a DA I apologize so much, Paulin, today. When I was a DA, the first time I was in busy Brockton court, and it was so busy, and defendants were a name on a file, and I say this because I was young and I was slightly embarrassed to say, but there were defendants I dealt with who I never really made eye contact with because I was so busy. And I realized going back after being a defense attorney, they're human beings, and I should look at who I'm prosecuting and try to understand them more as a person. Life's all about perspective, and my perspective changed a lot. I learned a lot from working for him, and I think it made me a better prosecutor. I hope it did.
It seems to me all the young ADAs worked pretty hard and paid very little relative to the work, right?
Yes.
And I would say that's probably not good for the defendants who are coming before the courts.
It's hard.
Part on the anecdote you just shared.
It is hard, and I'm sure I'm not the only one. I worked second jobs the whole time because I was making I worked at a retail store. I'd finish being a DA, and then I'd go and sell clothes for 5 hours, and I'd come back, and it's not easy. They worked hard, and some of them, they're so young, the life experience isn't there, and it's probably not the best situation, but that's sort of how it's always been. Young, not making a lot of money, working hard.
When I think about the collateral consequences you talked about, in your application, you talked about the balance between punishment and rehabilitation and deterrence.
Yes.
So I'm wondering, and I'd like to know your perspective on kind of the deterrence and punishment factors. So like losing your license as a simple thing, but determining a sentence as a more perhaps impactful thing.
Yes.
Do those have deterrent qualities to them? Like if I get a year longer sentence, is that further deter me from future crime in your opinion?
It depends on the person. I think that it may. I do think that collateral consequences can serve as a great deterrence. I do think for people who have a job and either license or have kids that license loss can be a very good deterrent. I think that a suspended sentence can be a good deterrent. I do think that jail can be a deterrent, but it does depend on the person. They're not one size fits all.
And you, especially as a defense attorney, but you've had occasion to visit houses of corrections in the Commonwealth. How recently have you been to one?
The last time I would have been there as a DA, when I would have witnesses there, I'd still go and visit my witnesses there. That was not on murder cases. Sometimes your witnesses are in jail.
What's your impression of, and our jails have a lot of problems, including difficult work conditions for corrections officers there, and, you know, all sorts of other issues, mental health among the folks who are there. In your experience in both sides of this, do people come out better off in general?
Probably not better off.
So, and I'm not picking on you, but so if they're not coming out better off, then how is the sentence a deterrent? It's almost it would almost increase the likelihood of recidivism, perhaps.
Well, I think if they don't want to go back, it's a deterrent.
Sure.
Right? It's an experience they don't want to experience again. It can work as a deterrent. And it also serves as the other factor, which is a punishment.
Right.
Jail is.
Okay. Have you had occasion to send people to state hospital?
Oh, yes.
And have you visited the state hospital recently?
Not a state hospital, no. I certainly have been to, when I've done 7 and 8s, I've gone to the locations, but I haven't been to, when I was training, I went to Worcester Recovery Center. I've never been to Brockton, and the facilities that out of the courts, which are not locked facilities, so they are where you go on a 7 and 8. So I've certainly done those, yes.
Sure. And as a judge, I assume you have authority to visit as counselors and other elected officials do. Is that accurate?
I'm sure I could. I've never, like I said, only when I had hearings, I certainly would go.
In the next couple of years, would you visit some of the places that are most commonly being, you know, your defendants are being impacted by or sent to?
I do think so. I've spent pretty much my entire career, except for when I worked for Attorney O'Malley, moving around in Plymouth and Bristol. And I do think it's important for the judges who are sending people to programs or facilities to be familiar with them, especially if you're going to be sending people to different, I do drug court, and there's different programs, and I do always like to familiarize myself with them and learn about them or go and see them, because I think it's important if I'm going to send somebody someplace, I know what they're going to be dealing with, so absolutely.
I appreciate that, especially on the diversion programs. Not all judges do that. My last question is, you're going to Superior Court. Are you familiar with the Harvard study commissioned by?
Yes, certainly.
And what was your takeaway from that?
I learned a lot. I thought it was very interesting.
Did you learn anything new, or did you find it particularly insightful?
I thought that the numbers were much higher than I expected them to be, as far as the differential between sentences and things of that nature. I don't mean to sound naive, but I think I was surprised.
And I think a lot of us were surprised, because we think of Massachusetts as being, rightly so, having a great justice system, and we do, but we also have problems. So, there's myriad factors that impact that. In Superior Court is where all the sentencing disparities actually happen. In District Court, things are pretty level from my reading of the report. The data is getting outdated already. So given that, does the judiciary have a role to play in remedying that? Because obviously there's, like I said, so many factors, mandatory minimums. Does the judiciary have a role in remedying this?
So it's hard. So there are sentencing guidelines which are advisory. When I was a DA, I didn't utilize the sentencing guidelines as much from my perspective, because I always had sort of an internal, based upon my experience, to try to figure out the value, what my recommendation would be. So, and I do know that other judges find that the sentencing guidelines could be helpful, because it does try to sort of keep the sentences similar in nature. But not all judges use them, and not all of them help them. So I think that it's difficult, because you want to try to be consistent with other judges, so someone's not going to one courtroom getting 9 to 10 and your courtroom getting a 5 to 6. But I think it can be also a tough balance, in that you're taking away a judge's discretion. So I don't think it's an easy solution. Yes, we have a role in it, but how we're going to remedy it other than forcing guidelines, I don't know exactly how. But I would always try to be at least consistent with myself, because I think that's the most important thing I can do is always to be consistent with myself.
Thank you, Mr. Chair. I have no further questions.
Thank you very much. Councilor Mary Hurley.
Good morning.
Good morning.
We had a great conversation.
Yes.
I've looked at your application, which is great. I've gotten some great calls about you. And our conversation focused on issues of bail
Yes.
and consideration of the victim.
Yes.
Those are the two things that are most important to me. Your answers were excellent, and by the time you get to me, it's been asked and answered. So I intend to vote for you, and I thank you very much for your service. I do think you're going to find the difference between Superior Court and District Court to be overwhelming at the beginning. So if you can keep up with the work, it helps a lot.
Thank you so much.
You bet. Take care.
Thank you. Councilor Joe Ferrara.
Thank you, Mr. Chairman. Nice to see you again.
Nice to see you.
Nice to see people from Bristol County. I apologize, I was late. I was held up in the Bristol County Juvenile Court this morning. But they took good care of us. It just took a little while to have a hearing. So sorry I missed all the, I'm sure the beautiful tributes by Judge O'Malley and Clerk DeSanto. I've known you for a long time. It's funny, I was just sitting here and was Googling some stuff, and you got nominated in 2017. The Sun Chronicle wrote a good article about you after you prosecuted successfully the Michelle Carter case, and DA Quinn talked about you winning 13 out of 14 murder trials. Unbelievable.
Thank you.
I've seen you in action. I've seen you down in Wareham. I've seen you in New Bedford. I've seen you in Fall River. You have the admiration and respect of people that I know, that I learn from and admire. You're going to make an excellent Superior Court judge. I was a Superior Court law clerk 150 years ago, 1992, so 30 years ago. I think the Superior Court's a great court, as well as the District Court. I think you take a lot more work home with you, from what I understand. So God bless you that you want to do that. You're going to make a great judge, and thank you for all your service to the Commonwealth.
Thank you so much.
Thank you. Councilor Robert Juvenile.
Thank you. Thank you. Good morning. How are you? Just to follow up on Paula's mention of the study done at Harvard. The bottom line for the conclusion as to why there was the discrepancies in punishment and sentencing inmates, just one word, racism. It struck me that all of the things they talked about, from the way the charges come down from the DA's office, whether or not somebody's case stays in the district court or they're indicted, whether or not somebody is sentenced harsher as a minority, all of those aspects that they pointed out have been in our system for many, many years. And of course, the disparate number of minorities per population incarcerated in the country is a big item that they spoke about. The way people get into our jails is by judges.
Yes.
So I know, I don't have to ask you this, I know what your response would be. You're going to be sitting now in a court where, unlike district court, where most people get probation programs, a percentage, I don't know what it is, end up going to the House of Correction, but that's usually a small percentage. So you're going to the Superior Court now, where the charges usually are much greater. And the fallout from a trial or a plea of guilty is, in a lot of cases, incarceration. How are you going to handle the built-in racism in this system that we see every day? And in my time in practicing, never even thought about it before that study. It never even occurred to me that this was this way to that extent.
No, it's interesting because I was thinking back to times when, and I know you were in Brockton District Court a lot back in the early 2000s, and we had the school zone measurement. In Brockton, every place was in a school zone. So everybody, we didn't break them down. Everybody was doing 2 in a day. And again, being young and obviously Brockton has a higher level of minorities in it than sort of the outlying towns, and you're realizing after a while, every person that I'm sending to jail on this is African-American, because they live in Brockton, and every place in Brockton is a school zone, and it's a minimum mandatory, and we're not breaking down, and that was the ultimate. And I remember very specifically being in front of Judge Deneen on a case, and the attorney made a very impassioned speech, and he essentially said, "I'm sorry, there's really nothing I can do. It's a minimum mandatory. She's pleading guilty. I'm sorry." And I remember sort of thinking, this really understanding the ramifications of the fact that we weren't breaking these down. Now, obviously, the school zone measurement has changed substantially, and the rules have changed. And I know at least when I was in Bristol County, we didn't ever actually prosecute school zones because they were very rare at that time. I think the best thing I can do is to treat everyone in front of me fairly. That's what I always tried to do as a prosecutor, and I hope I was successful. And if there were times when I was not, I hope that I've outgrown that and learned and understood that and as Kerry spoke about, I remember sometimes doing murder trials and that Counselor Ferreira talked about, and people would ask me, what was the defendant's reaction? And I would say, I don't know. I wasn't looking at him. I don't get any sort of satisfaction from evicting someone to spend the rest of his life in prison. I'm doing this as my job, and the victim needs justice, but I don't get any joy out of it. And that's why I always look at defendants when I sentence them. I think that if I'm going to send someone to jail, I owe them the decency of looking them in the eye and telling them what their sentence is. They're owed that as a human being. And that's what I always try to do. Whether or not they appreciate that, it's something that I endeavor to do as a judge, to treat people fairly and to look them in the eye and to always base my sentences on the factors, not on race, not on anything of that nature, not on gender, none of those things, to sentence them for the crime they've committed, but to employ all of the other factors and to sentence them as a human being, because I owe them that.
When you get to the Superior Court and you have people coming before you, it seems to me that grow up in minority areas of the Commonwealth have much more interaction with police than people who do not grow up in.
Certainly.
So when they reach, sometimes in the district court, but sometimes up in the Superior Court, they have much more interaction and have court interaction because of that. So they seem to get treated more harshly when the sentence comes up because they've had more on their record.
Whereas another person may not, just pot, essentially.
I don't know whether that plays into why there's so many more minorities incarcerated.
It could be, and if you look, and again, I certainly when I was in Bristol, and the same judges I'm talking about who were very guideline focused, and I remember the first time one particular judge, I had a case, and she said, one of the guidelines, I said, oh, I didn't look at them. I never made that mistake again after I said that. But obviously the guidelines change for whatever zone you are for your record. So certainly that's going to play a role in it. I think a record can be indicative of some things. Be helpful if the person hasn't been in trouble in a while, that could be helpful. Or if they went through their entire teenage years and this is sort of an aberration, that can be helpful information. But you're right, a record is not the end all be all either. How you should sentence somebody, certainly.
Well, I was always under the impression that when you made a mistake and you went to our court system and you got punished, whatever it was, you successfully completed your punishment. And you had squared yourself away with the court system. And you were going to start fresh again. But I see that really not the case because you keep getting punished through the court system.
Hold you around, yeah.
Because of that. So your debt to society was paid, but you're still going to owe some if you get ratcheted up on the other end by some judges. Mentioned about looking somebody in the eye and reactions from defendants. There was a judge who I will not name famous for, I don't know whether one case in Bedford, in Fall River we did, you might have even been on it, I don't know. The judge in a plea said that the client hadn't shown sufficient remorse or whatever, sitting there during the listening to the victims making their statements. And as a result, he was going to ratchet up the sentences that we had agreed upon with the DA's office. And it ended up, I ended up telling him, thanks, but no thanks, we're not taking this. We ended up coming back before another judge down there, and it was about 20 minutes, it was all done. But a lot of times you tell your client, especially in serious cases, not to make any, head gestures or not to show anything, not because somebody doesn't have emotion, but there's people in the back on both sides. And if the defendant starts making some sort of a gesture or a remark or whatever, then you're going to have a problem. So I just caution that sometimes everybody has different reactions.
Absolutely.
What's happening to them. And you hear it all the time, the defendant didn't show any remorse. Well, I don't know what he has to do. If he does show remorse, it's probably going to be that he's full of baloney, isn't just making it up. So it's a no-win situation sometimes.
Certainly, and I actually had that experience. I prosecuted two individuals for their role in the death of Lieutenant Weddleton. He was killed by two drivers who both played a role in it. And during the second trial, the gentleman had been very stoic during all of the entire proceedings. It was a bench trial in front of Judge Kane, very stoic throughout it, and he was convicted. And I still remember, because it was obviously a very important case to me, and I remember the defendant asked permission to come in front of myself and Atty Bomberg and the victim's family. He had several sons, and began weeping, and to tell the family how sorry he was for what he had done, and that his lawyers had told him that he wanted to reach out and he wanted to say something, but his lawyers had told him that that was not appropriate and he needed to act stoic to get through the trial. And it was like a light switch, and he just began sobbing. And I'm not the biggest crier in the world. I probably started crying too, because he was sobbing uncontrollably. So I agree with you that, one, people act differently to everything, but also that sometimes is good advice to have no reaction, because some people laugh or smile when they get nervous. And I remember specifically thinking he had been so non-demonstrative and then just broke down sobbing. So I agree with that.
Well, the nice thing about going to court all the time and meeting people in the court, get to know them, and I have had a lot of interaction with you over the years in the courts. And I think I may have said this at your confirmation for the judgeship, first judgeship, that you were always wonderful to deal with. You were a class act and prepared and a good lawyer, very good lawyer. And I will not be voting for you again after this time. We're going to get so many votes out of it. I will make an exception if you get nominated for the SJC, but other than that,
Back in my mind, thank you.
thank you
Thank you so
much.
Thank you so much.
Counselor Devaney.
Thank you. Nice to see you again.
Nice to see you
I
again.
have to tell you, my friend said, will you stop meeting with people who get your signatures for the ballot? I said, no, I can't. That's part of it. And because I'm not voting for someone on a paper, I'm voting for the whole person.
Yes.
And it was my pleasure and my honor to vote for you before. And when I saw your name coming out, that's what we should do. We should have people, excuse me, we should have people who have experience like you as a judge to go up to a higher court and bring that experience. So, but I first want to recognize your dad. And I want to thank you for your service. Served in the Marines. And I think was wonderful, I don't see this often, that grandparents have an interaction in taking care of the grandchildren because of location. And I have grandparents.
Yes, we talked about your son in New York.
So, yeah, but, I can't thank the city administration enough, because this is what we want people who are hearing. And what I loved about everything else that you said in your J and C, you said compassion is key to being an effective judge. And I've said it time and again, but anyone can have compassion.
Lieutenant Governor.
Now, I was going to talk about racial disparity, but my colleague covered that nicely, so I won't get into that. The other thing I was going to mention was the place that you had, where he just, detailed it about the place where the officer was killed. So I won't get into that, but it just, the experience that you bring is wonderful. We had someone that went to the Superior Court, Sabine Rodriguez, 6 cases in 21 years. That's not what we want. We want someone who knows the law, who knows the rules. And I love your involvement in all the courts. Judge Machera has talked about you. And I have gone to the drug courts, and I think it's very important. And, we talk about drugs for the last 4 years, and we don't seem to be winning that war. And I'm concerned about the lack of long-term drug treatment centers in Massachusetts. And I'm hoping you as a judge will join with other judges and lobby the legislature to fund it. Because I think it's only like 1.5% the judicial get, and we really need it. And it's increasing, it's not decreasing.
Do think the drug courts can be very successful. Judge Darnborough, who's in charge of the drug court down in New Bedford, he ran some statistics that he was talking to me about a couple weeks ago, and he had 32 or 33 recent graduates, and when he ran the records, 31 out of the 32 had no additional court involvement since they finished drug court, which is a very high success rate. So I do think they can be very helpful.
Right, no, I think it's very important, and I saw it firsthand. I saw the graduation, I saw these men and women drug addicted.
It's nice to watch.
And I sat in the back and cried. It was so beautiful that they turned their lives around. So, we talk about the mandatory minimums. I'm so opposed to that. I really believe the judges should have discretion. And I don't know, you could tell me if that's changed at all, but we had someone for a pardon here many years ago. He was 57 years old, and he got caught in that school zone law. He was 17. He was on his way to school, and he was stopped by a 21-year-old friend.
Okay.
And he asked him, this young fellow, if he would sell 5 bags of marijuana for $25 each. Naive, good kid, good student, good son. In the school, he sold 1 bag. Then when he approached another student, that student went to the principal and told. And so I believe at first it was 5 years, and it was reduced to 2 years. He made a mistake, and this was fallible. He wanted to plead his friend. And when he came before us, tears came in my eyes. Here's me, and it was life. He's had a lot of health problems. He had cancer, he had his leg removed. He married, he had children, and he's been involved in his community. And now he's out of a job because he was fortunate when he first got out of prison that he got a job as a janitor in a school, but now it's closed. So I thought, what is the chance? So he's got a patent. What's the chance of this man getting a job at that age with that baggage? And it really bothered me because it ruined his whole life. His graduation, his sports, maybe he would have got a scholarship to go to college, all of that. And so this hasn't changed at all. I mean, do you have any discretion?
Well, the scenario you described certainly has changed because of the changes in the marijuana law. And the, back when he was prosecuted, 17 was an adult, now it's 18. So he would have been prosecuted for that in juvenile court and certainly could have ended up with probation and it would have been his juvenile record. So in the situation scenario now, as far as minimum mandatories, we don't have a lot of, we, judge really have no discretion, but I can tell you in Bristol County, and I know I'm a little biased because I used to be a DA there, but I have seen that the DA's office is very amenable, if the situation appropriate, to breaking down the case from trafficking to intent to distribute, taking it out of the minimum mandatory sentence. So I do see a lot of that. I can't speak to as much in Plymouth County because I really was only there during the pandemic and we were just dealing with the day-to-day of the pandemic. But I do know that Bristol County, again, I'm a little biased, I worked for Tom Quinn for 10 years, but I do think he's a very, he really tries to not ruin a 17-year-old's life. That's not something he would ever want to do. So I do think that a lot of the DA's offices are, if it's appropriate, to break down the case out of the minimum mandatory type charging. And I also think that in that county, they take a lot of great care in their charging decisions before the indictment, before it goes to the grand jury, to try to make sure that it's appropriate and not just 17-year-old, you know, and then.
I'm very glad to hear that. It was quite different this time going through the JNC. I think it was almost 2 years before you got through. So
Yes, last time it was a
really
long,
believe-
it's been a shorter process.
thank you so much for applying because we need your experience. We don't need someone with, you know, 6 cases going to Superior Court. That is so egregious. And I can't support that. And we want to clone you. We want people like you to be on the Superior Court. And what I liked about you when we talked, you felt that you could do more in the Superior Court because there'd be more complex cases that you could see. But you've had a wonderful experience with judges and everything through the years. Now, your writings, and that's what the judge said about you. That's what really impressed me, because you have to love to write
Yes.
when you're on the Superior Court. And we had a judge that went back to district court because he didn't like all of the writing. And you have that ability. I saw that when you first came before us, and I said, why didn't you do this? So tell me about that writing that you put. Well, first of all, we did discuss in length about the two men, and that was tragic. Now tell me about your the writing that you put in about the break-in and.
Oh, right. That was a really interesting case that I had. I was really lucky. I had just become a judge, and it was a pretty complicated, from a judge's perspective, fun, interesting evidentiary hearing involving a lot of different. It was a house break, but the homeowner wasn't home. She was watching it on like a Ring camera, and so she called the police, and then there was a chase. So it had sort of it was almost like a law. Like a bar exam question. So there was a entry into the house, and then there was a stop, and there was a search, and then there was a search of the car, and it just I was very excited as a newer judge to get it, because I'm thinking I can really, sink my teeth into that one. So that was a longer sample, because I remember I was newer and didn't have as much of a backlog, and I remember sitting down, I spent days really writing and pulling out my favorite book in the world, the Red Suppression book, and really taking my time. So that was an enjoyable one to do. Yeah.
I look at your experience and I say, wonderful experience. The council voted a few months ago, 40-year-old white guy, to go to Worcester District Court, which is criminal, and he has no experience. He was one of 13 assistant solicitors in a city hall. That was his biggest job. So we really need you. I'd like to ask you, because I know when I met with you, how many, over 300?
So if you were to combine my trials as a lawyer and as a judge, I would say around 350 would be my best estimate. Somewhere between 325 and 350, definitely. Cases, tens of thousands.
They sent someone with 6.
Yeah.
So
Tens, if not.
know what it means to me to have you in the Superior Court, and we need more of you. And if we can get that message to the governor, We don't want someone learning on the job, and you have such experience, and I saw that in you when I first saw you. And it was such a pleasure meeting you again, and everything was so fast. We had so many in one day, and that you accommodated me to meet with me, and I'm grateful for that. It was really nice to catch up with you, and your son is 12 now.
He's 12 now, I know, it's amazing.
So, the thing is, you know, when you think of your experience, and it's more criminal, how do you think that benefits us to have you on the Superior Court?
Well, I think that it's, you know, it would be very difficult probably to find the unicorn, someone who has a lot of criminal and a lot of civil experience. I think that's probably a hard person to find. So I do think, some civil, I do think that you're always going to, generally speaking, and you guys know better than I do because this is what you do, but you're going to find someone who's heavier in one side or the other. So I think I bring a strong criminal background. I have done a lot of murder trials. I've done a lot of sexual assault trials. I've done a drug case, a little bit of everything. But I do have some civil background, but I do really know the law. I really pride myself in knowing the rules of evidence. I really enjoy reading case law. In the morning when we get the emails, I like to get up and I read what just came down. And I love talking to my colleagues. Judge Sorrenti and I often will have conversations about the case that just came down and, regarding our different views of it. And I do really like staying up on the law, whether it's civil, whether it's criminal. So I hope that I can bring that strong background. But I hope that my strong criminal background means that they can just put me in a criminal session and be ready just to go with whatever comes in front of me.
All of these trials and cases, what stays with you that maybe it's rewarding or maybe it's disappointing, the outcome, but what one would you please stand on?
I think probably my very first murder trial I did because of the circumstances, a little bit of everything. One, it was my first, so I was terrified would be probably the best word to describe how I was feeling. My son was actually still in the NICU. He was finishing up his stay. He was there for about 100 days, and I couldn't move the trial for a number of reasons regarding witness availability. So I was waking up every morning, just as I had for the 90 so days, visiting my son in the NICU at 5 o'clock in the morning, driving to court, putting on my case, driving back to the NICU, seeing my son, and then preparing for the next day. It was a complicated case involving, there was a lot of DNA, which was new to me, which I loved to learn about. There was fingerprint evidence, which was newer to me because it was sort of a newer science when I first was a DA before that. And it was a guilty on all three theories of first degree. And the victim was he was a nice young man, 18 years old. He was brutally killed on Christmas Eve. A huge loss to his family. So I think that probably was most rewarding because personally, and then the day after the guilty verdict, my son came home from the hospital. So, and I took a whole bunch of time off from maternity leave. So I think as far as personally and professionally, that case probably means to me.
Well, I didn't say this to you when I met twice with you. So, having said that, I'm just so thrilled you're here, and thank you for applying. That's the major thing.
Thank you so much.
I wish you all good luck. Thank you.
Thank you very much. I don't have any questions. We had a long conversation at my law office. It's great to see all the people here today. You've done a great job as a judge in the district court. I think you'll even do a better job in the Superior Court. And I'd be more than happy to put your name before the council next week at our weekly meeting. Thank you very much, and thank everybody for coming.
Thank you so much.
And I would ask Counselor Hurley to lead us in prayer and pledge today.
Yes, thank you. I would offer a prayer of hope and consolation for all of the victims in Ukraine and for the speedy downfall of the second Hitler. The Russian president should be ashamed of himself, and hopefully someday he'll get his due. A little bit harsh, but I think well-deserved. Amen.
Amen.
Thank you. Pledge allegiance to the flag.
United States of America. One nation, under God, indivisible.
Liberty and justice. Another.
Oh, it's just an oldie but a goodie. I'm sure you know what that means. All right. I recognize Counselor DePaula for a motion to record advice and consent for the financial warrant.
So moved.
Second.
Motion and a second. All in favor, say aye. I recognize Counselor Kennedy for a motion to record advice and consent for the pending list of notaries, public, and justices of the
So moved, Governor.
Second.
Motion and a second. All in favor, say aye.
Aye.
Counselor Jubenville. Looking for a motion to record advice and consent for the appointment of Joseph M. Griffin Jr. to the position of Associate Justice of the Boston Municipal Court.
So moved. Second.
It is a motion and a second. Counselor Devaney.
No, I just want to thank you and the administration for presenting Joseph Griffin. He is so qualified and he has everything I look for, especially the humility. He has high-profile cases that we've all read about in the paper, and I won't go through all of that. He is highly qualified. But I want to say that Lieutenant Governor, we just salute the flag and we say justice for all. And, it really isn't justice for all the nominees that come before us. That particular day when Attorney Griffin came before us, we had another hearing for Judge D'Angelo. And with this nominee, Joseph Griffin, I was very happy. This room was filled. In fact, people were sharing a chair. That's how filled it was, okay? Everyone was here, his family, his friends, his relatives, supporters. Now, it was not justice for Judge D'Angelo. He was instructed, do not bring anybody. You come alone. This chamber was empty. He could not bring his wife. He could not bring his 6 children.
Point of information, is this relevant to the nomination?
It's personal privilege.
We do this.
Personal privilege.
And we have a motion and a second relative to the matter before.
And I know judges would have filled this, and attorneys would have filled this room. It was an inquisition. There was no questions asked of what he's been doing for 16 years. Only Counsel Ferreira asked question. But I'm just saying, let's be fair to everyone. No one should be, I never thought I would serve where counsel would make a nominee cry. He cried, and I cried. No one should be treated like that. Everyone should be treated equally. They should be able to bring their family, their friends, their supporters. And I know Judge Green wanted to come and all those judges, and he couldn't wait to get him on the appeals court. It was a wonderful nomination. And I'll tell you, Judge Dolly was devastated when he left here. And I just want to say, let's be civil, let's be fair, let's treat everyone the same, whether it's a friend of the council or whether it's anyone. And I'm just making that statement. It wasn't fair that that man sat alone in an empty chamber.
Okay, your point is made.
Thank you.
Yes, Counselor Jubenville.
Well, first of all, D'Angelo wasn't on with Griffin. That was back a few weeks ago. Already heard from the counselor from Watertown get up and say the exact same speech, I think 2 weeks ago. Make sure that the press is here when she makes it. And she got it all wrong, first of all. Judge Dolly was not upset at all. I speak to him constantly. He had no problem with any of this hearings. And second of all, it is up to the counselor chairing the meeting to decide on the procedures that are going to be taken. As I said the last time the counselor from Watertown brought this up, this was a contentious hearing. We all knew it was going to be contentious. So I said to him, I would not bring your wife if I was you because you're going to be asked some hard questions and she might be embarrassed. I said, you can come in and you can bring your witnesses and we can have the hearing. There was an indication that there was going to be 9 or 10 judges brought in here. As I said the last time that she brought this up, that was a very bad idea. It was being used for a purpose that it shouldn't have been used for. And I explained that to the nominee. He agreed with me and called the judges off. So he had a good, fair hearing. It was a tough hearing for him, but he did a great job, I thought. And in fact, we voted on him, I believe, last week, if I'm not mistaken. So and he passed, I think, by 8-0 or 7-1, I forget. So he had a very fair hearing, but it's up to each counselor to decide how they run their hearings. And I don't criticize any other counselor for the way they handle them. And I would expect and hope that no counselor criticizes other counselors before the body. If you have a criticism, do it downstairs or when you're with the counselor alone. Don't do it to play to the press. So that's all I have to say. Thank you, Lieutenant Governor.
Okay. Thank you both. We have a motion and a second. We may begin the roll call.
Yes, sorry.
Yes.
Yes.
Yes. Yes. Yes.
Yes.
Yes. Okay, thank you. I recognize Councilor Hurley for a motion to record advice and consent for the appointment of Brandon D. Freeman to the position of Associate Justice of the District Court.
I make that nomination with a great sense of pride in the nominee. He appeared before me. He was always a class act, and I think he's going to be a great judge.
Second.
Thank you.
We have a motion and a second. Councilor Devaney?
I just want to add that when I met with him, he mentioned being before Judge Hurley and what a good experience it was, and to have her recommendation, and beside him being so qualified, I'm happy to vote yes.
Okay, thank you. We have a motion and a second. We may begin the roll call.
Yes.
Yes.
Yes. Yes.
Yes. Yes.
Yes.
Yes.
I recognize Councilor Hurley for a motion to record advice and consent for the appointment of Barbara Y. Burton to the position of Clerk Magistrate of the Chicopee District Court.
I make a motion on this nomination with a great sense of pride and history. I've known Barbara Burton for not only my time on the bench, but when I was a practicing attorney. She was a great addition to the Springfield District Court as an assistant clerk. She's been at Chicopee for several years as the acting, and I'm sure she's going to do a great job there. Thank you. So moved.
Okay, we have a motion and a second. Thank you. We may begin the roll call.
Yes.
Yes.
With pleasure, yes.
Yes. Yes.
Yes.
Yes.
Yes.
Okay, thank you. We have 2 nominations that need to be scheduled, and I believe you've organized that. One is Christopher Belazos to the position of Associate Justice, and that hearing will be June 1st at 9:30.
9 a.m., 9 a.m.
9 a.m. 9 a.m. for Christopher Belazos, and Elizabeth Dunnigan to the position of Associate Justice of the Superior Court will be the same day, June 1st at 10:30. Thank you. And we have 4 nominations today. They are being reappointed to the Department of Industrial Accidents Board. And they are Catherine Watson Cozio has been nominated for reappointment. Councilor Hurley, do you have a date and time for this hearing?
I'd like to put it on for May 25th. I'm just checking what else is on for that date.
We have 2 other matters.
It's 2.
So you do the afternoon.
We have one at 11:30 and the other one at 10:30. 10:30 and 11:30.
It's the 25th.
But what, you know,
They're quick, 1 o'clock you can do.
Okay.
These are reappointments.
All right, 1 PM. Seal.
Okay. John J. Bennett III, he's also been nominated for reappointment, and that's in your jurisdiction, Councilor Jubinville.
Why don't we do that next week at 1:30? Are you doing yours at 1?
Yeah.
1:30.
On May 25th at 1:30, okay? Karen A. Fitzgerald, let me just finish with
I'm not sure.
there are 4 nominations that we're discussing, and these are reappointments. They are currently serving on the board of the industrial accident, and they have been part of this process before. Karen A. Fitzgerald has been nominated, and that also falls in your jurisdiction, Councilor Jubinville. Okay, that will be at 2 PM. And Dennis M. Maher, Councilor DiPaolo, is within your jurisdiction
We will do that on May 25 at 2:30.
at 2:30. Okay. All right. We've got nominations. We have the schedule, May 25th and June 1st. That concludes our business today. Thank you.
Devaney, and I will have the pleasure of presiding over this hearing today. And first of all, I just want to have a little ground rules first. I'm going to ask everyone to put their cell phones away. That means counselors too. It doesn't work, but I try every time. The other thing is, if anyone is going to speak, would you stand now and take the pledge? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you very much. So, welcome, Judge Ellis. Nice to have you back. You belong. I will start with, first of all, reading a letter from the governor. And the governor reads, "Dear councilors, I am pleased to nominate Sarah Wayland Ellis to the position of Associate Justice of the Superior Court. I submit the nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience." So I welcome you. And before I have you introduce everyone that's here, I'm going to introduce my colleagues. First, Councilor Hurley, Councilor DiPaolo, Councilor Kennedy, and Councilor Duff. That's who is attending. Now, you can tell us, everybody here attending.
My pleasure. Thank you so much, Councilor Devaney, for hosting this meeting, and to the councilors for being here. I'm joined today by one of my witnesses and my dear friend, Maya Saraf-Frain, another witness, and someone I have the pleasure of working with in the Waltham District Court, Probation Officer Daisy Barbosa, my third witness, who may be my first witness, and my mentor judge, Judge Stacy Forts, Sarah Adamson, who became a good friend of mine in the administrative office of the district court, my father, John Wayland, my daughter, Chloe Ellis, my son, my husband, Don, my mother, Marilyn Wayland, retired Sergeant Detective Stephen Fournier, who was for years the police prosecutor in the Waltham District Court, who I had occasion to work with when I was a new DA up through when I was a judge, and he retired. Behind Councilor Hurley, we have Detective David Savoy, who is the current Waltham District Court police prosecutor. We're joined by Waltham Assistant Chief Court Officer Mark Mischel, who in many ways is the glue of our courthouse. I'm joined by Joe Jackson, who is the DCA for the district court, by Sergeant Detective Dean, who's our former police prosecutor in Waltham District Court and has moved on to other accomplishments. We're joined by Joseph Dickhoff, Justice of the Appeals Court. And I'm sorry I don't know this gentleman here, but we're also joined by Aaron Thomas, who has the important role today of memorializing these proceedings. So thank you.
Thank you. No, it's such a pleasure to see the judges that I voted for. Thank you. The first, I'm calling your witnesses is the order that you've given me. And the first one is the Honorable Stacy Fortes. Welcome back.
Thank you, Councilor Devaney. Would you like me to sit here?
Yes, please.
So let me start off by saying that I am truly honored to be before all of you, but deeply honored to be here in support of this nominee. I have had the pleasure of working with Judge Sarah Ellis for the past 8 years now in a variety of capacities. First introduced to her in 2014 when she was Deputy Legal Counsel and Director of Legal Policy for the Administrative Office of the District Court for Chief Justice Dawley. I had an opportunity to work with her, observe her during many judicial trainings for judges that she helped to put on during our annual judicial conference. She would provide updates and give advice to judges on the law on a regular basis. But I really got to spend some time with her when she was assigned to work with the criminal committee of the district court, for which I was a member. And the district court criminal proceedings committee was responsible for a variety of things. Updating the jury instructions, working on forms, pretrial condition forms, model plea colloquy. So I had an opportunity to work closely with Sarah on all of those things, as well as other committee members. One of the things that I discovered immediately when she was a lawyer assigned to the administrative office, and I think that every colleague would tell you now about her, is she is one of the smartest, most thoughtful judges that we have in the district court. And I think every judge, no matter their level of experience, judges who have been on the bench for a long time would say that she is a valuable resource to all of us. I've had an opportunity to work with her as the regional administrative judge. When she was appointed, we were all thrilled to the district court. I was particularly thrilled when Chief Justice Dawley assigned her to sit in the region for which I'm responsible for administrating. As she mentioned in her remarks, Chief Justice Dawley also called and asked if I'd be her mentor when she was appointed as a judge. It is the easiest assignment he has ever given me. I tease her and tell her that often I would just call and say, everything okay? And that would be the extent of the advice that I would give her. She has been a fabulous judge in the district court. She has worked in every court in the region. Many of you are familiar with some of the courts in the region for which I'm responsible. Lowell and Lawrence being some of the busiest courts in the region. She sat in those courts, handled jury trials, bench trials, motions to suppress, you name it. She most recently was assigned to sit in the Waltham District Court, where she sat with the late Greg Flynn, a beloved colleague for all of us. I think one of the things that really speaks to who she is as a person is that when Judge Flynn was diagnosed with cancer and undergoing treatment, I called him and I asked him, what can we do for you? And he said, there's only one thing, Stacy. Please keep Sarah Ellis as the second judge in the Waltham District Court. And for those of you who've worked with Greg Flynn, there are a couple things that we all came to know about him. He was an excellent judge, and he cared deeply for the community of Waltham and for those that the court served. So it said a lot that he chose Sarah to be in the court with him while he was undergoing his treatment. When he retired in December, and Chief Justice Dawley was going to appoint another first justice, he also fully supported Sarah as the first justice of the Waltham District Court, and she's done a tremendous job there. We've all experienced a lot of challenges during the pandemic in keeping the courts running and justice being administered the way it should be. And she's done an outstanding job there. I have mixed feelings about her appointment. I think we all do. Chief Justice Dawley said last week in a conversation that I had with him that we're all very proud and excited for her, but the Superior Court's gain will be a tremendous loss to the district court. She will go to Superior Court, I think, as a mentor for other judges in the Superior Court. And I'm happy to be here.
Thank you very much. Your testimony means a great deal to us. And thank you for your service. Anyone have any questions? Councilor Kennedy.
I just want to appreciate the fact that you mentioned Judge Flynn. He was somebody that I was fond of, who I had a lot of respect for. He was a good and decent man. When he passed away, I didn't know his family, of course, but I knew how close Judge Ellis was to him. So she was the person I called to offer condolences, because I appeared in front of him since the day that he was appointed, and he was on a long time. He was just a very decent man, and I'm sure if he were alive today, he'd be sitting next to you, ready to beat us all up to make sure we vote for her.
Thank you, Councilor Kennedy.
Any other councilors have any questions? Well, I thank you, and proud vote right there. I really am. You made us all proud. The next witness is Probation Officer DZ Barbosa. And did I pronounce that correctly?
It's pronounced Daisy.
Okay, Daisy,
Thank you.
welcome.
Good afternoon, and thank you for having me today. As you all may already know, my name is Probation Officer Daisy Barboza. Currently, I am a probation officer over at Waltham District Court, where I had my first encounter with Judge Ellis 3 years ago, where she sat on my interview panel. Fast forward today, I've been over at Waltham District Court for 3 years, and but prior to that, I served as an associate probation officer for the Cambridge Juvenile Court of the Middlesex Division. I'm in here today. I really did not want to sound too cliche, as most of the things I'm going to say are things that Judge Ellis probably already know. However, I wanted to speak from the heart, and I think that that's the best way to convey my message and convey and speak about Judge Ellis. So I plan to do just that. I want to start off by simply saying thank you. Thank you for being an amazing person. Thank you for being an amazing mentor. Thank you for always treating everyone you come across with respect, with courtesy, compassion, and dignity. Thank you, but most importantly, thank you for being a judge of reason, a judge of fairness who always makes decisions with patience, tact, and integrity. Judge Ellis, that is really a true reflection of who you are as a person and an honorable justice. My opportunity of working with Judge Ellis will be something I forever will remember. I can give you a million examples of how great she is as a person. However, I will say some of the moments that are memorable to me were your moments of guidance, especially as a new probation officer in the district court. Everybody knows how terrifying that can be sometimes. I will say that some of the moments that stood out to me the most were the moments of guidance. Those moments developed me to becoming a professional who look at the totality of situations before making decisions. I became a probation officer who upholds the court orders while treating my probationers with respect and still being able to be assertive and firm while upholding court obligations. Your humility has always been transparent as a leader, and us over at Waltham District Court is beyond have had you serve as first justice. Although I am saddened to see you go, I am so happy that others will continue to experience what we have experienced. Thank you for always representing the criminal justice system to its highest honor. I really mean that. Thank you.
That was from your head.
Thank you.
Any councils have any questions?
Thank you.
No. Thank you very much. Next witness is Maya Saraf Frame. How did I do?
Perfect. Good afternoon to the members of the Governor's Council. I'm honored to have been invited by Sarah to speak on her behalf in this forum. Thank you all for giving me a few minutes to share some thoughts about Sarah as you consider her for a position in the Superior Court. I feel so fortunate to count Sarah as one of my closest friends. Sarah and I met almost 25 years ago when she and my husband Brian were classmates at Boston College Law School. During that time, Brian and I also became friends with her husband Don, who was also a BC law student, and we've remained very close ever since. Our children are all within 3 years of each other and have grown up feeling like cousins. Sarah and Don have welcomed us at many family gatherings, so we've been able to get to know her parents, Marilyn and John, and her sister and her family as well. Over many years, we've been friends. We've enjoyed vacations together, outings around the city, and spent countless evenings sharing dinner and great conversation. It's with 25 years of knowing Sarah that I can so enthusiastically support her pursuit of her role with the Superior Court. From a personal perspective, Sarah possesses all of the qualities most valued in a friend. I hold Sarah in the highest regard, and it's difficult to describe in just a few minutes what makes her so exceptional. Sarah is thoughtful, caring, and willing to have tough, honest conversations when they are most needed. She cares deeply about her family, her friends, and her profession. She's a natural leader, and her confidence, intelligence, and empathy elicit respect from all who spend time with her. While Sarah and I enjoy a friendship based on shared values and interests and have spent lots of time laughing and having fun, I've also had an opportunity to peek into her professional world. About 2 years ago, my husband was appointed to the bench as an Associate Justice of the Juvenile Court. Sarah was an invaluable resource to Brian in considering service on the bench and shared both the rewards and challenges that are inherent in the role. Sarah's comments always reflected the immense respect she felt for the courts, the public served by them, and the staff that supports their operation. She spoke about the law with a passion that drives her to meet a very high bar every day in her role in the district court. Since my husband's appointment to the juvenile court, I've had an opportunity to gain a deeper understanding of the qualities it takes to be a good judge. Sarah treats everyone with respect and understands the importance of due process and the right to be heard. She is experienced, smart, and decisive. She's compassionate and has the capacity to be fair and balanced. The fact that Sarah has become a leader among her peers is a testament to her legal knowledge, personality, and hard work. She is someone who brings out the best in those around her because she demands the same high standards of herself. I've often joked with my husband and others that know us that while I'm a little older than Sarah, I say one day when I grow up, I want to be Sarah Ellis. Her poise, kindness, and intelligence are apparent to all who know her, and her leadership by example elevates every team she is a part of. I have no doubt that she would bring all of these qualities to the Superior Court to the great benefit of each courtroom where she presides. Thank you so much for your time and consideration.
So, have any questions? No questions? No, thank you very much. I really value that. Is there anyone here that's not on the witness list who would like to say something about this nominee in favor? You chat. All right, hearing none. Is there anyone in opposition? Hearing none. Now it's your turn, Judge, for your presentation.
Thank you very much. First, I'd like to thank the governor's counselors for your consideration of my confirmation and for holding this hearing today, and to Councillor Devaney for hosting this hearing. I'd like to thank Lieutenant Governor Karen Polito and Governor Charlie Baker for the honor of this nomination to the Superior Court. I'd like to thank Bob Ross, legal counsel to Governor Baker, and Lauren Green Pedrigno, the deputy legal counsel to Governor Baker and the executive director of the JNC, for their consideration and their support. To the members of the Judicial Nominating Commission, I thank you for allowing me the opportunity to be a part of this process again. I would like to thank Chief Justice Paul Daly of the District Court, retired Chief Justice Paula Carey of the Trial Court, retired Chief Justice Judith Fabricant of the Superior Court, and Chief Justice Heidi Brieger of the Superior Court, who I understand had a conflict with today's hearing, for the opportunities they've given me to work for them and with them on important work impacting our court system. I'd like to thank those that I've previously introduced who were here today to be my witnesses. I know that it was difficult to run the region and come here to testify for me today, and we do have many court officials here. So I recognize if you need to leave at some point to get back to court, and it's an open session, so you can leave at any time. But thank you for being here. I'd like to thank those in this room who have supported me, believed in me, and encouraged me throughout my career. I'd like to thank my parents, Marilyn and John Wayland. My parents encouraged my talents, solicited my opinions, and taught me to believe in my own abilities. They supported decisions I made, whether that they agreed with them or not, and they fostered in me the self-confidence to go to law school, to be a litigator, and to stand up and to speak out. My mother is a retired middle school guidance counselor and English teacher, and from her I learned to examine and question my own feelings, motives, and beliefs. She encouraged my sister and me to widen our perspectives to better understand where other people are coming from. My father is a retired computer systems analyst who attended graduate school in the evenings when I was a young girl to earn his doctorate. From him, we learned to tackle problems with patience, precision, and persistence. From both my parents, I learned the value of hard work, as well as to love learning for learning's sake, and that it is a privilege to be able to dedicate yourself to work that is also your passion. My sister, Laura Twilliger, who cannot be here today, is a true optimist, and I deeply support her lifetime of love and loyalty. I'd like to thank my in-law families on the West Coast who may be watching this feed, to Steve and Helen Ellis and John and Bobby Bridge. From the beginning, you've accepted me as family, and your love and your support has been very important to me. Thank you to my husband, Don, who I met in 1999 at Boston College Law School. And as we approach our 20th wedding anniversary in just 2 weeks, he has been my steadfast champion and ally. He has always encouraged me to follow my heart, to trust in myself, and he has supported me throughout. Finally, I'd like to thank my 2 daughters, who are ages 16 and 13. When they sat over here just 5 years ago, they were kids. And I could not be more proud of the individuals they are growing into. My younger daughter could not be here today as she has her middle school theatrical debut this afternoon, but my older daughter is here. And I appreciate that both my daughters are compassionate, loyal, smart, kind, funny, diligent, and brave. I am excited to watch them find their passions, pursue their goals, and to make the world a better place. My desire to be a public servant grew in part from the many values I learned from my grandparents and my parents. I didn't grow up in a family of lawyers. The Freed, Fogelson, Ronan, Whalen melting pot from which I am immediately descended had many smart, creative, and driven people, but their talents didn't lead them to the study of law. I was raised with an emphasis on education, intellectual curiosity, hard work, and self-sufficiency, with a strong emphasis on being true to myself in all circumstances. I wanted to become a lawyer because my experiences taught me that the law is a powerful tool to help others. In college, I worked as a receptionist, typist, and clerk in a small medical malpractice firm. There I met people who had suffered debilitating injuries and illnesses who had turned to the law for recourse. In the state's attorney's office in Maryland, where I volunteered through many of those same years, I assisted victims of violent crime and their family members who were waiting for trial, scared to testify, but finding the courage because they believed our legal system would deliver justice. Being a judge in the district court for the past 5 years has been a privilege and an honor. I have seen the impact that poverty, lack of education, substance use disorders, trauma, and mental health have on the lives and choices of people appearing before me every day. It has been immensely rewarding to use my education and experience to serve our communities, as well as parties in need of the court's intervention. The work of the district court is immediate and impactful. The colleagues I have had the honor to work alongside in the district court are serious about our work, dedicated to serving the people before the court, and wonderfully supportive to each other. When I worked in the administrative office of the district court for Chief Justice Dali, I valued the intellectual aspects of the position, including the opportunity to delve into many of the district court's more complex legal matters. I participated in multiple initiatives across trial court departments, analyzing how legal, procedural, and statutory changes could advance the administration of justice. Our work was focused both on continuing to improve the court system as a whole, as well as examining specific and often novel legal issues as they arose. And I found this work to be interesting and engaging. Until I joined the district court bench, I didn't realize how much I missed the direct connection of my work to the lives of specific people. Every day I make decisions that directly and immediately impact the lives of individuals before the court. My decisions resonate in the communities that I serve. I am very aware of the responsibility of my position on the bench and my role as a public servant. I embrace these aspects of being a trial court judge, and I find the prospect of positively impacting the lives of those before me to be extremely motivating. My hope is that, should you vote to confirm me, sitting on the Superior Court bench will be an opportunity to build upon both my ardent intellectual curiosity and my strong desire to serve the public. Presiding over complex civil and criminal litigation would be exciting to me academically, but I also appreciate the high stakes and the deeply personal nature of such cases for those involved in the Superior Court. I would endeavor, as I do now, to treat all litigants with respect, compassion, and dignity. Judges are called upon to keep an open mind. Over the past 5 years, I've had the opportunity to reflect on this directive. It's often used as a figure of speech more than an instruction. What does it mean truly? to keep an open mind, to truly consider something that way. We all bring our unique life experiences, perceptions, and references to anything that we consider. The challenge to approach each case, each litigant, each circumstance with fresh eyes appears on its face to divorce us from our history and experience. So in practice, what does that mean to keep an open mind? To me, keeping an open mind is about humility. As judges and those here who practice in our trial courts, we see a lot. People on their worst days, in crisis situations, and impacted by trauma. Writer and novelist Paul Auster wrote in his work, The New York Trilogy, "Every life is inexplicable. No matter how many facts are told, no matter how many details are given, the essential thing resists telling." For any person appearing before the court, we judges see the aspects of a litigant presented to us, but we cannot appreciate all the complexities that has led each person to the circumstances that they face. We may study legal concepts comprehensively, but we are constantly challenged to apply these concepts to the unique lives of the people before us. A dear friend to many of us here lived by the phrase, "There is nothing more ignorant than certainty." This is an important and central mantra to any judge. The promise we make as judges is that we will be fair and we will be impartial. To do so, we must be active listeners, we must patrol our consciousness for bias, and we must be humble enough to recognize limitations in our own knowledge and experience and keep the open mind necessary to process new ideas, arguments, and perspectives. Those before us are deserving of decisions made with reason, compassion, and humility. I'm deeply thankful to this Governor's Council for the opportunity to serve as a district court judge. 5 years ago, you entrusted me with this position, and I've worked to honor your confidence and your trust. If confirmed to the Superior Court, I am confident that I would continue my career on the bench in a manner that serves the public fairly and utilizes my professional and personal strengths. Thank you. I look forward to any questions you may have for me.
Thank you very much. I open up to the council and we go by the rules and I will call on Councilor Duff.
Thank you. You know, I'm very impressed with you, your resume, your education, liberal arts education, which I'm a big fan of. Share with your parents the ability to read and write, which I think is underestimated today. And Kenyon College is just a tremendous place to have studied as an undergraduate, so well, good on you. I also liked very much that you spoke about your children as being brave. I think that is, I think being brave and having courage in this world is two things we all need to have, a lot of them that they're hard to have. So I hope they can continue that with the guidance of you and your husband. I really only have one question. We didn't talk about it. It's not in your resume. Do you like baseball? I have two questions.
So I was in drama club. As you know from our conversations, I am, to my detriment, not a particular sports enthusiast, and my husband is grimacing as I say that, and you have Justice Dickoff behind you. But I have to admit to my own deficient knowledge in the area of baseball.
Okay. I had an algebra teacher that would sometimes write VOD on our pages, benefit of the doubt. So I'll give you benefit of the doubt on that. Who would you root for? Baseball.
So that is also a loaded question.
It is a loaded question, and think
So I know that the hometown carries the day in this conversation. I will say that my family's from New Jersey, and my husband grew up with a grandfather in Seattle, but who grew up in New Jersey. So I have to admit, especially if my uncle's watching.
These guys are looking at you like,
I know. So now's when everyone leaves. I enjoy watching the Red Sox play baseball.
Done. I have no further questions.
Council Kennedy.
I started interviewing you for this job the day you started in the DA's office. Well, I don't have to ask you any questions. I've been asking you questions for a decade and a half at least. So I'll vote for you.
Okay, Councilor Paula.
Thank you. Well, the weighty issues are out of the way, so I have some inconsequential things. Anytime I get multiple phone calls from Councilor Kennedy about a nominee, it raises a lot of red flags. So hopefully this goes okay. So whenever I ask this, I preface it sometimes with the disclaimer that I have no problem with prosecutors. I entered law school intending to be a prosecutor. My first summer internship was in the Suffolk County DA's office. The Child Abuse Division changed the trajectory of my life. And Justice Dickoff, no way he remembers, but he gave me the opportunity to write 2 appellate briefs that summer. So it was a great summer. And if the ADAs were paid more, I would have gladly pursued that path. Nonetheless, I do concern myself with balance on the bench. And so we do continue to have a preponderance of our judges coming from prosecutorial backgrounds. And I know obviously you've been on the bench for some time now since that experience. But how can you assuage my concern about having a broader perspective than just the prosecutorial mindset?
Well, I would rely on my track record on the district court bench. I have endeavored to be fair and balanced. I think that my experience as a prosecutor was important in terms of my education and my frame of reference. And I think one of the things that you learn in that position, especially as it relates to district court, but really superior court as well, is that both defendants and victims come to the equation with a lot of obstacles. And people who are defendants before the court may have in the past been victims of other things in their own right. And life is difficult for people. I spoke in my remarks about poverty, mental health, lack of education, substance use disorder, and that's something that we see every day, and it limits the choices of the people before us. So I think that both my experience as a prosecutor and then reinforced by the past 5 years, that I've learned that compassionate and understanding is central to what we do.
So when's the last time that you had a chance to visit a House of Corrections facility?
So I went when I joined the district court bench, I believe, and before that, I probably visited the Bill Ricca House of Correction at least 3 times as a prosecutor. We preside over cases in our early judgeship in different, all over the state. So I've been to, for instance, the Worcester prison, which is also a mental hospital. So I've been to various, I would say, facilities that also act as houses of correction.
And do you think it's important for judges to periodically visit these places?
Absolutely. Because if we're sentencing people to the House of Correction, we ought to know what it means and what a hardship it is.
Something you said about, understanding victims, defendants coming before you have been victims of something ahead of time. In your application, talking about discretion, one factor you raised was victim impact statements. And I'm wondering, how does a victim impact statement, or does, in your opinion, a victim impact statement help a judge to apply the law to a set of circumstances? Does it have any impact on how the law applies to the underlying incident?
Potentially, it does in the context of sentencing. So as you know, under the Victim Bill of Rights, judges are required to consider victim impact statements, either written or oral, before the judge decides on a sentence, even if it's an agreed tender of plea. So it's important to me that if a victim of a crime wishes to make an impact statement, that they have the forum to be heard, that I'm not predetermining the sentence before I hear from them. How that crime impacted them and affected their life might inform what conditions of probation that I think are appropriate. For instance, if it's a relationship where the victim felt that alcohol use was a component, or the intimate partner abuse education program. And it also, frankly, may inform the severity of the punishment if this was a crime that was particularly egregious and had a lasting emotional impact on the victim.
If the victim's not there, or if the victim, for whatever reason, hasn't been as impacted as another victim for a similar crime, does that lead to a stiffer sentence because of that?
That's a good question. I think it's hard to answer in the abstract just because I try to judge every case with the specifics about that case that are before me. And victims are informed of their right to make an impact statement by the district attorney's office. And often that office represents to the court what the wishes of the victim are, or whether they don't perhaps wish to be heard. But I try very hard to consider a variety of factors before I decide upon a sentence.
Okay. You, I believe, currently serve, although I know that your application was written, I don't know how many months ago, on the Trial Court Committee to End Racism and Systemic Barriers to Justice.
Yes.
That's quite a title for a committee. In the time of your application, you wrote about intending, it sounded like it was in its infancy. What's going on there?
So that is a trial court committee, and I'm turning to Judge Forts because Judge Forts leads the district court committee on racial and ethnic fairness. And this committee in particular is a trial court committee of which there are different working group subcommittees. This subcommittee of which I am a member is led by Judge Paul Smith. And yes, at the time that I applied, the committee was just at its early stages. And to a certain extent, we still are. The committee, the jury subcommittee, is looking specifically at what obstacles exist that would impede the right to a fair jury trial. And we intend to examine topics such as the use of peremptory strikes, whether hardship excusals are related across the board to low-income jurors, jurors who need childcare. We're also looking at the felony exclusion, which right now I believe is a 7-year felony exclusion, and ought that number be shrunk. But in order to examine these questions, we're very much in the data collection mode right now. And as you know from the Harvard study, which went into depth on the different methods to collect data, relying on one database alone is insufficient. We certainly have access to mass courts. In the Harvard study, they cross-referenced the mass courts data with decisus, and that's important to drill down on individual cases and numbers of defendants.
Do you believe that there should be more data collection and sharing among some of the organizations in our justice system? Do you believe that we're missing important data, especially in the Harvard study?
So I think one of the obstacles, I've thought about this a lot on the basis of the different committees that I've been a part of. I think one of the main obstacles is that a system like mass courts was purchased and used as a case management system with a very discrete purpose within the trial court. And we're now asking it to generate information that it wasn't necessarily designed to collect and might be collecting inconsistently based on individual practices in courts. And I think it's important for the court system to look at that across the board to see where we want to go in the future and what's the information we need to pull out of it, and then educate the employees of the court system about how to input that data. But to your question about sharing data, I think that we saw the power of sharing data in that study, which was so specific and came out with, I think, important results for everyone to know of.
You very well know then that the sentencing disparities along racial lines happen in Superior Court, where Black and Latino defendants are twice as likely to be brought to when there's concurrent jurisdiction with the district court, which obviously exposes them to longer potential sentences, but also, in fact, does result in longer sentences for similarly situated defendants. Entering Superior Court, do you have a role to play in addressing that?
Yes, I think every superior.
How does a Superior Court judge or any judge, how would you approach that process?
So as you know, minimum mandatory penalties do play a part, and that's a charging decision. But as you point out, what the Harvard study showed us is that there is a role for the judiciary as well, and that even in minimum mandatory sentences, what the data reflects, accounting for different variables, is that people of color are sentenced to longer sentences. So I think the first component of this is awareness and education. And I think it's important to recognize when you're looking, for instance, at a criminal history, that if someone is living in a certain city or town, at a certain poverty level in certain communities that have lower income levels, that they may have more points of contact with law enforcement. And that may result in more entries on their board of probation record. And that people don't start with an even playing field on these issues. And I think it's important to bring that education to a review of the different factors that you're considering when sentencing someone.
I appreciate your time this morning. I have no further questions for you.
Thank you.
Thank you. Counselor Hurley.
Yes, thank you. We spoke at some length. I reviewed your application, which is amazing. The fact that you are the co-chair of the Education Committee for the District Court speaks well, not only of you, but of Mark, who was there for a long time. I served on that committee. I know how in-depth the work is. You get exposed not just to criminal, you get exposed to civil, all different kinds of issues that are for not only our court and the district court, but throughout the court system. So I really don't have any questions. Got phone calls from Judge Smith, a number of other judges that I've known, and also from Tina Cafaro, who were part of the Education Committee mentor team that has her being put through her paces. And the word she used was awesome. And it's not the only time I heard awesome, unbelievable, incredible work ethic, etc. I really don't have any questions that have not already been touched upon. My big thing is protecting victims while giving defendants a fair trial, and that includes the issue of bail. We talked about that. So I regret the loss of you in the district court, but I applaud your willingness to work. I think I described it as the district court deals with short stories and the Superior Court deals with novels. So your willingness to get involved in oftentimes multi-issue matters that can take a lot of time and a lot of thought and a lot of effort. I am confident that you will be a rising star in the Superior Court in short order. So I am going to vote for you. Thank you very much for your time and good luck to you.
Thank you, Counselor Hurley.
Thank you.
Counselor Ferrara.
You and I have spoke several times, and you have a plethora of unbelievable letters from high-ranking people. Your reputation is stellar. I'm not one to ask questions for the sake of asking questions. I applaud you wanting to go to the Superior Court. I was a Superior Court law clerk 30 years ago, and I appreciate the work that the great Superior Court judges do. Take home work and work at night and weekends. So I applaud you for one. I thank you for your service, and you're going to be a great Superior Court judge. You have my vote next week.
Thank you, Counselor Ferrara.
Thank you.
Counselor Joseph.
Thank you. To follow up on Councilor Paulo's about the study from Harvard, it's been about, I'm guessing, 3 years since the study came out, or is it 4?
I feel like it's closer to 4. I'm sorry, I don't have the date of this study.
So we all know about it now, at least everybody that's read the study. Do you feel that anything has changed based on that in our court system?
I hope so, but I can't answer that specifically because
don't know what the sentencing and pretrial detention statistics reflect. But I know that the court leadership has made it a mission to educate judges that study. It is required reading. And I think a lot of the aspects of that study are important for judges to consider when looking at all of the variables that lead you to a bail decision all the way to sentencing.
I haven't obviously done any studies after that study, but I am in the Superior Court a lot and the District Court a lot. And I don't get a sense it has changed. I hope I'm wrong, I hope it has, but I don't get that sense. I think the charging by DAs hasn't changed much. The discrepancy pointed out in the study is that Black and Latinos get charged or indicted more than whites or proportion of population. I still feel hasn't changed much. And of course, everybody plays a hand in what the study said was one word for what's going on in our system was racism. The only word. So I know everybody plays a hand in it. I mean, that the charging authorities charge and it winds up in the lap of a judge. Better or for worse, you're stuck with it, right? To some extent.
Sorry, stuck with what?
With the charges that are before you and the defendant comes up. And again, I haven't done a study on the amount of incarceration since that, but I hope I'm wrong, but I don't get a sense it has changed much. And the only way people end up in prisons or houses of correction is because the judge puts them there. I get the sense that the minority members of our state that live in minority areas of our state interact on a higher level with police and individuals that don't live in those areas. As a result, the more contact police, the more chance that they're going to get charged with a crime. I don't see that change much since the study, but again, I could be wrong. So from the study, what do you glean you can do in the Superior Court? Yes, bring your knowledge on the issue, help in any way you can to alter the course we've been on up to the study and maybe right up to now.
I think it's important to bring an educated eye to the information that's put before the judge about any individual before the court. One of the things that the study talked about is people of color, young men in particular, being charged with gun and drug offenses at a higher rate than people who are white. And to your point, the judge does not control what the charge is, but we certainly can look at someone's criminal history, to look at where they live, to see what those early interactions were with law enforcement, and to decide how much weight to give that information on the basis of the challenges that that particular individual faces.
I get the sense that racism is baked into our system since 1780 when we started having courts in the Commonwealth. And I think it ended up pretty pervasive through our system in ways that we don't even recognize it. I bring up the point that I've, for all these years in the court system, we look at a person's record. If that looks right, look at it, the DA looks at it. Make our arguments based on it. But it seems to me, and this is just my own opinion, that there is some racism in that issue. Because the people that live in the minority areas, since they have more of a chance to interact with police, or a chance to end up with records, get sentenced more later on in their career when they come into a court. The same individual from a affluent white community probably interacts with police but doesn't get charged as much. So I believe I've been told all my life that somebody commits a crime and they're punished, they do their punishment to the Commonwealth, that's it. They've done their penalty, and that's the end of it. It's not the end of it in our court system. It's used again and again and again. You give higher sentences, mostly in proportion to minorities. But that's just a thing I've thought up in the last couple of years, that issue of just the sentence. I may be wrong in it. Maybe there's nothing to do with racism. I don't know. But it seems to me that may be one of the reasons why that disparity in our correction system is there. When you're on the Superior Court, you can look inward. I thought you had a wonderful resume when you came before us for the district court. And I thought then you were going to make a wonderful judge, and I haven't heard anything that would dissuade me from that today. And I've received a lot of calls and letters that came in for you. Madam Shara called me over the weekend, spoke very highly of you, obviously. And I think you've done a heck of a job on the district court, and I think you'll be a good asset to the Superior Court. So I will vote for you. I don't know how many times I'm going to have to keep voting for you.
Thank you.
Thank you very much.
Thank you, Counsel. Welcome back.
Thank you.
It was just such a pleasure when I saw your name going to Superior Court. Thank you for applying. First of all, I've got to recognize your mother. And she's sitting in the governor's chair. But you might not know it, but Judge Ellis and I share this. My name is Marilyn, and my late husband was John. You're like your mom and dad. So having said that, I'd like to ask you, when did you think of going up to the Superior Court? What was it that gave you that, that innovation to say, I think I could do better, I could do more?
I wouldn't say better because
I don't mean that word. That's not a good word. But
I love the word
complex, more complex.
Yes, so for me, it was a decision that I started thinking about approximately a year ago, maybe perhaps a little bit longer. The work in the district court that I've gravitated to, that I've found most fulfilling over time, has been the more complex legal issues. I was talking earlier today about the unicorn that is the 4-day district court trial, and I've been fortunate to have some complex, interesting, and impactful jury trials in the district court, and the thought that I could do more of that, and that I could tackle more complex issues is really interesting to me, and I think it would be very fulfilling.
Well, I couldn't be happier being here 23 years to have someone like you with your experience as a judge going to a higher court. I mean, I've seen in the past years someone with 6 cases that went to Superior Court. That's not right, and it's not fitting to represent the people of Massachusetts. So I thank you. You have brought, you have been involved in programs that I haven't seen with other people that come before me for a judgeship. And I really would like you to talk about that. One of them was your judicial trip for equal justice. I have talked on and on about, I'm very concerned about racial equality and the racial bias in the Massachusetts schools. And we talked about that when we met. Thank you for meeting me again at the diner. And, you are on the Hall of Fame for the Belgian waffle as Judge Dickoff and Judge, so I thank you for that. But tell me about that. Tell me what you gained from that and how you proceeded with that, what you learned.
So as you may know, our late Chief Justice of the SJC, Ralph Gantz, organized a trip for judges to go down to Montgomery, Alabama, to visit the Equal Justice Initiative, which is a museum and monument that was created by Brian Stevenson and his team of colleagues. And what the museum examines, and I was able to take my husband with me, who went on that trip as well. What the museum examines is the history of the African-American experience in this country, beginning with the slave trade, the experience of enslaved people, through to the Civil War. My daughter studied AP US History this year, and we had a lot of discussions about the information from that museum and how it did or did not track the information that was taught in their curriculum through to the Civil Rights Movement. And the museum really makes the case that the mass incarceration of young men of color in this country is a direct offshoot of Jim Crow's legacy. And it makes a compelling and impactful argument for that position. The other, aside from the museum, there's also a memorial to peace and justice. And that memorial is a memorial to everyone in this country who was lynched. And it's staggering. It's the way that the museum is set up when you walk in is that there are monoliths that hang from the ceiling that memorialize every death due to lynching by county. And as you travel down the spiral of the museum, these monoliths are turned on their side so that they go from looking like tombstones to looking like gravestones, graves. And it's staggering. And I'm so thankful that I had that experience. I hope that we can take our children to that museum in the future because I think it's important for children to grow up with that information. And after the trip to the museum and the memorial, the judges met with Chief Justice Gantz and shared our reflections, our hopes for the court system, and ways that we saw we might be able to effectuate change.
Right. Also, which is something I'm concerned about, domestic violence, and you were on that domestic violence and sexual assault council. So what did you bring from that to, to help you in your position as a judge?
In the district court and in the superior court, we see a lot of domestic violence, and sexual assault crimes are some of the most serious cases that come before us as judges. We were looking, when I first joined the committee, at education initiatives for judges and for all court staff. Before I joined the bench, when I was part of the administrative office of the district court, I worked with Judge Mary Ann Hinkle to come up with a training curriculum, which is required by statute beginning in 2014 for all court personnel to receive training on domestic violence, to understand what reoffense and fatality risk factors are, to understand the directive to sentence for certain crimes, to intimate partner abuse education program, and also to understand that defendants who are charged with crimes of domestic violence were often, as children, the victims of domestic violence themselves, that it is truly a vicious cycle in that regard.
I want people here to know that I ask questions. I don't ask questions for the sake of asking questions. I know this judge. I have met her for hours when she first came before me and last week when we met again. But I want people out there, thank God for public access now, to hear why this person is qualified, why she's experienced in her personal life. And that's why I ask questions. So the council doesn't like me asking questions, so they established a 15-minute rule that I'm ignoring today, okay? And it's supposed to be only 15 minutes between the counselor and the nominee, but you deserve to talk about your achievements and what you've been involved in. I was very interested in your involvement with Justice Agnes, wonderful, wonderful man, and Judge Tikoff. You are involved in some publications, and you're still working on one with the judge here, but tell us about that. I know, but you tell us.
So Justice Dickoff is smiling. So as you know, Justice Dickoff and I had the honor of working together for Chief Justice Dolly at the Administrative Office of the District Court. We started on the same day. We had cubicles right next to each other, and working with someone as smart as Justice Dickoff, you learn a lot. But to your question about Judge Agnes, so Judge Agnes, as you know, is the president of the Flashner Institute at this time, and he has developed several publication initiatives for Flashner. And Justice Dickoff and myself and others across court departments are working to write a book on probation violation proceedings. So that has been an opportunity for us to continue our academic interaction and our friendship. And I've also been working with Justice Hanlon on publishing a book on harassment orders.
No, that's great. No, that's something that we don't hear of, and I want to give you the opportunity to talk on that. The other thing is your publications. That's to me very important that you've taken the time to write things. And tell us about the publication you wrote about, what was it, I'm trying to think, the jury proceedings, or what was that one particularly? I'm trying to think.
I'm not sure. One of the publications that I had occasion to write about
Was it probation, or I don't remember. Oh, I know, drug courts and how they impact participants, courts, and communities. And I have gone to drug courts, and I've said this before, I went to the graduation and I cried. Those people who were drug addicted for years and alcoholics, and what this program did for them. And it was just, I sat in the back and tears came to my eyes when they talked about how it changed their lives. And I wanted to know, these specialty courts, are they productive? They are. They really are. So tell me about that, right?
I had the opportunity to work with Judge Hogan Sullivan, who at the time was fulfilling a specific role for the trial court in terms of attempting to accredit our different drug courts. And in doing so, I worked with her on writing the drug court guide. I think Justice Dickoff had a piece in that as well. The drug court guide to lay out a map for drug courts to be reviewed by experts and accredited. And after that, I had the opportunity to write that article about the actual impact that drug court has had on the lives of specific individuals. I'm looking at Judge Forts because Lowell has a very robust drug court, and I think for all of the judges who've presided over that, and we try to use the same, judge who gets to know the litigants, who gets to understand their personal histories, and therefore can hopefully craft sanctions that are immediate and specific to them. We find drug court to be difficult and rewarding.
Right. I had to bring this up. It's about someone in public office that you took on that case and taking money from the parking meters and everything. And I'm just going to give a little history to the people here. The judge was Judge Sikora. I'm going to tell you about Judge Sikora. He had a case in the district court on Halloween, and he instructed jurors to come in Halloween costumes. Can you imagine, as a priest, as a nun, as a traffic post, as a clown? That's Judge Shakur. So he was the judge, and you brought that before him, and you could tell us about what that woman did and she was responsible for the money. And you tell us.
I'm happy to talk about it. I was not in Halloween costume. That did not come up in the context of that trial. But that was an embezzlement case that I tried in the Superior Court as a prosecutor. And the embezzlement scheme involved a woman who worked for the City of Lowell parking clerk's office. And she was accepting payments for parking tickets, and she was logging the payments as having been made with the Registry of Motor Vehicles, because there was a direct connection between how the clerk collected the money, their computer system, and then how that was forgiven through the registry so that it wouldn't result in a license suspension. Well, she became sick. And she wasn't in the office for several weeks in order to make those corrections within the computer system, so that people's licenses were starting to show up as suspended when they knew that they had paid the parking clerk the money. And so the complaints started coming into the City of Lowell about that. And there was an investigation that was launched, and there was an audit that was performed, and it was extensive. And that was a heavy paper case on the one hand that involved bank records.
It was about 44,000, yeah.
Yeah, it was over $40,000 when it was all said and done, but it took a long time to uncover the amount of the larceny and the number of people that were impacted, as well as understanding all the repercussions of that in terms of their Registry of Motor Vehicle status and all the other fees that they had to pay because of that. Eventually, everything came to a head when other members of the office discovered envelopes of cash taped under her desk in the parking office, and then they were really honing their investigation on her. And one thing that was interesting about that case, when you have that amount of money, is you wonder what happened to the money, and that was never discovered definitively, although it was believed by her colleagues that she had a gambling addiction, as well as her husband, who testified at the trial for the defense. But it was a fascinating case. It took a lot of financial investigation to build the case, and she was convicted.
I can't go over everything, all your cases, because they're just fantastic, but one of them was a case, and we talked about it, where there was a driver that killed a police officer, state police officer, that was on a detail. And you want to tell us about what happened?
So I'm not sure what.
Well, what happened was she was driving and ran over the police officer and killed him. And so I thought that you judged properly and you gave her a sentence. It wasn't a light sentence, but was proper for what happened. You don't remember that?
I don't remember that specific case being in front of me as a judge. I certainly have had the opportunity to examine, in the context of the administrative office of the district court, different police officer fatalities and judicial decisions that were made regarding license status leading up to that in terms of an after-action analysis. But I don't believe that I've had a case as a district court judge regarding.
Anyway, it was a short term, but I thought it was appropriate. And I'm going back to my history and my knowledge of judges. And there was a case where a woman in her 50s was speeding and ran over and killed a local police officer who was on a special detail at a construction site. And the officer had a wife, 5 children, 13 to 2. And when it went to court, the judge ruled, I told you, the judge ruled suspension of her license for 6 months. And then he turned to the widow holding the 2-year-old with her other children and said, "Do you know what it is to go without a license? You can't drive for 6 months." I don't want that kind of a judge. And I just said his name before, I'm not going to say it again. And that's what I see. So I do my homework, and I really, I have been so proud of my vote for you. I vote for Judge Bliss, my judge, Judge Ditkoff. I'm very proud of it. And when I do occasionally vote no, I tell why. I document it, and it's documented in our office. So, but So when you look at your district court experience, is there one case that you look at, maybe with pride, maybe with sadness, but it's something you'll always remember?
Well, one case that comes to mind is the case that was the basis for my writing sample, where I was reversed by the Supreme Judicial Court on an issue pertaining to harassment orders. It was a case out of the Lawrence District Court involving high school students and a song that one of the students published about another student who had been in his chemistry class the year before, and the lyrics involved a series of threats to commit physical harm against the student, his girlfriend, and the student's family members, involving threats to shoot and to rape and other disturbing threats. I extended the harassment order, and the issue, the legal issue, was what constituted 3 separate acts. I made written findings, and the case was appealed to the appeals court and then to the Supreme Judicial Court. My analysis, I recognized at the time, pertained to novel legal issues, ones that had not been decided specifically in the past. And I made the best judgment that I could at the time. I felt because there were separate crimes that were threatened against these individuals, that although there was one song, there were separate lyrics that constituted the threats, and because the song itself was published on different social media platforms directed at different audiences within the high school and beyond, that those acts constituted separate acts under the 250-80 harassment statute. I was wrong. The Supreme Judicial Court found that because it was one song containing these lyrics, that those were not separate acts, and because the song was created on SoundCloud, which is one of the social media platforms distributed on SoundCloud, and then distributed by way of Snapchat, that was one continuous act, I think perhaps given because the time parameters. And so I was reversed, but I think it was an important decision because we deal with those issues all the time, and it's always helpful to have the guidance.
Well, you know what comes to mind, and maybe it's not in the under harassment, but when we think of that young man who got over 1,000 emails from a young woman to commit suicide.
So I know you had the hearing before me with the judge who, as a prosecutor, had handled this.
That's the thing, I'm sure those cases don't come up very often before you, and they are hard. Of course, I'm very opinionated, and I just feel he came out of the car, and perhaps he would have, he changed his mind, but she insisted he go back in. So I don't know. I mean, I just can't thank you enough for going to the Superior Court, because you're going to get those kind of complex cases that judges 20, 30 years ago never had, you know? So I want to tell you, I got a lot of calls, but I had a long call with Judge Frank, and unbelievable. It was so nice to catch up with him, and he couldn't say nice things about you. And Judge Machero, he said, she's the smartest person I know. Now, you don't hear that adjective, smart, by people coming in talking about, you know, you hear it in general, but he really emphasized that. So I do want to, you know, tell you that. But we got a lot of letters, and I do want to recognize them. One of them was from Maryland, where you work for, who'd you work for? Root, what's his name? Judge Root? Yes. And he said that, you know, that you were so talented, and everything you did was excellent, and your judgment was outstanding, and he's followed your career in Massachusetts, and he is just so supportive of you, and he said you will make a perfect Superior Court judge. So you served the community with distinction. No better appointment could be made. Nice. And then Judge Judith Fabricant. And this is how many there are, so I can't read all of it, but I do want to say that, you know, she talked about in particular during COVID, how you carried on. And I just want to intersect something. We talked about this, and I told you I was very concerned about the 209As, because you even did it on the phone. And I'm saying, how do you know? You're not in person, you don't have eye contact, you don't see body language, and you're going to determine if this person is being truthful. That to me, what people don't know, what you people have gone through during COVID, decisions you've had to make, and maybe looking back, it might have been the wrong one, but you had nothing else to go on. It was all, on the phone or whatever. So you got through that.
Well, I have to take this opportunity to thank the Waltham District Court, because we learned a lot about technology during the pandemic, and we quickly realized that the phone conversations were not a way to hold court, and the trial court got Zoom licenses, video conferencing license for us, and it was a team effort. And I'm looking at Assistant Chief Mitchell, who often not only is our court officer, but is our tech support in the first session, to train everyone in the courtroom and the clerk's office and the judge on how to start Zoom meetings, on how to bring people into Zoom meetings, and to run sessions both on a computer screen and also in person, often simultaneously. We've worked hard to get cameras into the courtroom that allow parties to see each other, even if one is in person and one is on Zoom. And because of the pandemic, it's permitted people who have COVID or been exposed to COVID, even at this point, to continue to participate in their court hearings.
Well, I have to tell you how important it is for me to know your relationship with the people in the court, that you care about people, you care about all of them, and that's why they're here. That means a lot to me. And I always say I won't vote for anyone without compassion. And you got it stamped on your forehead. So I'm very pleased in that. So Judge Fabricant said a lot of good things about you. And she said that, that she recently persuaded you to apply for this appointment in the Superior Court. Isn't that something? So she said that the governor has chose you, and she's fully qualified by intellect, skill in legal analysis and communication, dedication, and temperament. She works hard, she is kind, sympathetic, and humble in manner. She listens carefully and openly, and she makes decisions. She has strong leadership skills, which I particularly value as a former Chief Justice. I considered it my duty to seek out and cultivate potential leaders through appointment of judges to positions of regional administrative justice, committee chair, mentor for new judges, and the like. Judge Ellis has demonstrated she has it all. If you vote to confirm her nomination, I expect to see her in positions of leadership before long. I recommend Judge Ellis for appointment to the Superior Court without reservation. Thank you for your consideration, and please feel free to contact me. We got a letter from Trial Court of Massachusetts, Chief Justice Paul Dolly. And he's writing in support, and he said it was a privilege to work with you as Deputy General Counsel in the Administrative Office of the District Court for 2 years, and more recently as the Associate Justice of the District Court for the past 5 years. He has the highest recommendation for your confirmation, and he said it will be a significant loss to the District Court. I'm certain that she will be an outstanding Superior Court judge. I can attest she's highly respected by her colleagues in the District Court and members of the bar. Since her appointment in the District Court in 2017, she has demonstrated superior trial and legal skills, strong work ethic, highest level of integrity, and an exceptional commitment to the court. She has earned a strong reputation in the respect of her judicial colleagues for her hard work and sense of fairness. Judge Ellis contributes to the trial courts are significant. She currently serves as First Justice of the Waltham District Court, co-chair of the District Court Education Committee, chair of the Jury Management Advisory Committee appointed by the Supreme Judicial Court, a member of the Supreme Judicial Court Advisory Committee in Evidence Law, a member of the Trial Court Committee to End Racism and Other System Barriers, and a member of the Jury Trial Working Group. She has handled these responsibilities in a highly competent and professional manner. On a personal level, she is a wonderful friend and colleague. She is honest, caring, and dedicated to her family, friends, and colleagues. In summary, I believe she possesses the professional and personal attributes to be an excellent Superior Court judge. I enthusiastically support Judge Ellis' nomination as an Associate Justice of the Superior Court. If you have any questions, contact me. This is a letter from, Judge Beverly Cano. And she said she's known you for many years. Without reservations, she can't think of a better candidate. She met you when you joined Judge Justice Dolly's legal team, and your stellar reputation as a prosecutor was something she has long known. She was a public defender for 24 years before becoming a judge, and she recognizes in Sarah not only her exceptional trial skills, but the fact that she is a person of the utmost integrity and was a prosecutor from whom you could expect fair dealings. As a deputy general counsel, director of legal policy for Judge Dolly, Judge Ellis helped establish the professional excellence for which her office is known. She is instrumental in educating judges on topics as diverse as domestic violence, uniform rules of impoundment, civil commitment and substance use disorder, and sentencing best practices. When she was appointed as the district court, she continued her teaching and committee work. In fact, Chief Justice Budd was so impressed with her that when Chief Justice Fabricant retired as the chair of the Jury Management Advisory Committee, Justice Budd appointed Judge Ellis as chair. This was extraordinary, as traditionally the position had been held by a Superior Court judge. When Judge Ellis was a newly appointed district judge, she appeared in Lawrence District Court, where my son, Frankie, was an ADA. At the end of her day there, Frankie called me to tell me that a new judge sat that day and that she was excellent. He commented on how smart she was, how she knew the law, how she treated everyone with kindness and respect. I have since heard such comments about Judge Ellis from so many people. You know, these are very long, so I'm going to stop there, but I just want to put that out, what people think of you and know you and believe what a wonderful Superior Judge you'll be. And so she ends up by saying the same qualities that have made Judge Ellis an outstanding district judge will make her an outstanding Superior Court judge. She's practical, balanced, fair. She is a critical thinker, and she is confident in her abilities. Judge Ellis treats all who appear before her with dignity and respect. I urge you to look favorable on her application. The next one is Judge Joseph Ditkoff, and he wants to express his enthusiasm for your nomination, and he got to know you in March 2014, when you both started as administrative officer of the district court in the same day. He was general counsel, you were deputy. To say that we served side by side for the next 2.5 years would be an understatement. There was not a single project which I did not rely on her expert assistance generously provided. She was instrumental in our efforts to address the opioid crisis, to reform the treatment of substance and disorders, to implement new laws to address domestic violence, and to address reforms in firearm regulation. And he talks about your humility and unflinching integrity, devotion to justice, and your kindness. And he enthusiastically supports you to be in the Superior Court. And he said that he personally has knowledge of your judicial performance. And because of a recurring medical appointment in the Waltham District Court, I have repeatedly dropped in and witnessed Judge Ellis in action. I have watched her work through tricky, ethical issues with an attorney whose demeanor demonstrated that he knew he could trust Judge Ellis to treat him fairly and with respect. I have watched her connect with litigants and help them to understand what was expected of them and to navigate the litigation process. I have observed her treat the clerks, court officers, and other court staff like valued teammates and friends, and that's what I said that it's important to me. So in essence, he said that he was working together on a bench for judges with you, and we're going to hear from you about that when you've completed it. And he said, I cannot think of anyone who would make a finer Superior Court judge than Judge Ellis, and I commend her nomination for your favorable consideration. And we got a letter from Ryan Dugan, Waltham Complex, and he said that he's honored to write the letter, and he is currently the Chief Court Officer for the Waltham Complex since March of 2020. And he talks about that you have been steady and a calming voice inside the court and during these unprecedented times in the court system, dealing with COVID and the many aspects it's presented. You have always asked for the security department directives when it came to court business. You've had several meetings with all the departments with him and always included and respected any discussions that you've had. And he witnessed firsthand your command and control of a busy session in a way that is calming and respectful to all parties. There have been many cases that a defendant has been affected by substance abuse and has been before First Justice Ellis. And in every way, you have taken command for that person, for the hard work it takes to deal with the substance abuse. She takes the time to acknowledge families, friends that are in court, to support the defendants, and express how much it means to the court that they are here to support their family member. He talks about your leadership, and he said the staff in Waltham is a very close-knit team, and that atmosphere comes right from First Justice Ellis. It is with great pride that I'm able to write this letter and hopefully express the level of professionalism and caring that we have for Judge Ellis here in Waltham. And then he asked if anyone wants to this. And we have one from First Justice Megan Spring. And she talks about serving with you, and you have a reputation of being intelligent, hardworking, and kind. And you work together, and she said you were a champion of hers. And she said She read my application and prepared me for my interview to the district court bench. Sarah has consistently been an excellent mentor, and she has treated almost every new judge who has come through the district court in the past years with respect. And she is respected and beloved by her colleagues. If she is confirmed by this body, it will be an enormous loss to the district court. They all say that, but an immense gain to the Superior Court. Serving as a Superior Court judge requires a slightly different skill set than the district court, and Sarah is more than capable of handling more complex legal matters, longer motion and trial practice, and increased legal research and writing. Sarah is smart, intellectually curious, patient, and possesses an unmatched work ethic. Cannot think of a more qualified candidate, both in intellect and temperament, to serve on the Superior Court bench. And the last one is from Judge Marianne Hinkle. And she talks about how she served. She has served for 17 years in the first justice of the Woburn District Court. And she talks about how you closely work together, and you quickly became one of the most active and involved members, and you developed an online education program. And she talked about how you covered advanced domestic violence issues, orientation programs, and served on the judicial response system. And she wants to say that you will be remarkable. She was a remarkable district court judge. Many of us with far more years on the bench than Sarah reach out to her for advice on a regular basis. In years before I joined the bench, I had an opportunity to appear before Superior Court judges. I am truly sorry that if Sarah is confirmed to this position she now seeks, we will lose her extraordinary talent in the district court. But I'm confident that Sarah's intelligent judgment, demeanor, communication skills, remarkable work ethic, and the passion for the work of a trial court judge will make her an outstanding Associate Justice of the Superior Court. Over the years, Sarah and I have become friends. On a personal level, she is kind, compassionate, thoughtful, caring, generous with her time and attention, ethical, and totally devoted to her family. She is, in short, one of the finest people I know. I recommend her to you without reservation. And I know a lot of councils don't read them, but this is important. This is about you, and we have public access, and I want people to know who the governor is appointing and how the council respects you. And I'm sorry, I want to thank Councilor DePaula for giving the respect to this nominee. Thank you. And so with that, I thank you all for all your patience. And I'm going to adjourn. And next week at our assembly, when the Lieutenant Governor chairs the hearing, I will be very proud to put your name in nomination. And it's been my pleasure. And you have to come back to the diner, gotta get that Belgian waffle.
Thank you.
Thank you. I adjourn. Thank you all for coming.